Yes.
My lord, memo, my lord. Contempt matter. BD has not executed absolute sale deed. Hence, we have filed the contempt in 1 year back, my lord. It's a 2023 matter.
1 year back.
1 year back. My lord.
It is not listed.
Notice is issued,
Not
but
listed.
not listed. My lord.
So what you are doing for 1 year? 20th.
Grateful.
My lord, this
Yes.
contempt
My lords, serial number 60, my lords. It's
60.
60, my lords.
60.
Please, my lords.
Yes.
It's coming for the order for the first
It
time. my
is
lord.
for office objects. No.
Please, my lord. Office of my lords. I may seek with
3
permission.
weeks time. In all office objects matter, 3 weeks time.
Grateful. Interim order may be extended, my lords. I shall undertake to comply the objection.
Pardon?
Interim order may be extended.
Interim order is there.
Please, first time it is coming, my lords. I shall undertake to comply by next date.
How can there be interim order in office office?
My lords, that matter was heard.
Now we are vacating it.
My lords, that
There can't be interim order unless the office objects are removed.
my lords, my lordships.
So remove it before on or before this 19th.
Please.
Objections to be removed on or before 19th of,
Grateful.
19th
Till then,
of
I shall.
June. Failing with the petition shall stand dismissed with vacation of interim order.
Great.
Without order of and reference
No,
to the court.
Grateful.
my lord, this is a contempt petition.
We will not permit any interim order to operate in a matter where office objects are not removed.
My lords, one request, my lords. In that matter, my lordships had observed that it was a frivolous petition filed before my
Whatever
lordships.
it
So,
is. Yes, yes, madam.
My lord, this is a contempt petition. There was a direction to the DC to remove encroachment. Despite the lapse of almost 1 year, they still haven't.
When you have filed?
My lord, it's of the year 2021.
Oh,
They had
28.
that they had already complied, but they haven't.
28. 28. 20.
Can we had on the
19th. 19th. All right, 19th.
19th.
My lords,
Yes, Mr.
First matter, my lord, great appeal matter pertaining to minimum wages.
It will be listed in accordance with
My lord, already
Listing.
writ of appeals are
listing
pending
norms. No,
before
no
the Honorable
memo.
Court.
Sorry.
The same have been listed on 19th, my lord.
Maybe.
Matter may be can be posted on 19th.
Yes.
one
My
second.
lords, kindly, my lords, one matter which had come up last week, my lords were pleased to keep it for today. Item 40 in the list.
My lords had indicated we'll take it up at 2:30. My lords, could it be?
What is that matter?
My lords, the last week the matter had come up. My learned friend had come from Delhi and I was also here, my lords.
Yes, regarding the.
It is about
Regarding
what?
KIDB allotment, my lords, that had been cancelled. We have put up the constructions.
Three, you just think. After, we'll take it.
But
Unless it reaches earlier.
Very well, very well.
One submission. Serial number 61, my lords. It's an election matter. Serial number 61, my lords. It's an election matter.
Yes.
Lordship, the matter pertains to excise license. The license here ends next week.
Pertains to
Excise license.
excise license,
License. The license is deceased and the legal heirs are not being permitted to obtain the license.
but it belongs to this court.
Yes, your lordship, writ appeal.
Writ appeal law. So what do you want?
Tomorrow or Tuesday, your lordship.
24th.
My lord, serial number 43, for respondent counsel is under medical care. I press 2 weeks adjournment.
43, you want?
43.
I appear for the appellant, my lord.
Any objection?
No, my lord.
The three matters? No. So it will go to July 9. 10 or to 9 July as requested
52,
by law and advocate for the appellant.
Serial number 42, my.
Yes, Mr.
Serial number 52.
Yes, you are on.
Serial number 61, my lords. It's an
60.
election matter. It's an election matter. We sought directions.
Which direction?
We were supposed to file documents, my lord. Documents is ready.
No,
We have
no,
engaged.
no. Office and don't
No,
mention.
it's office, not office objections, my lords. We were supposed to file some documents. Matter was heard at length. Mr. D.R. Ravishankar, senior counsel, argued the matter. So documents are ready. We are ready for arguments, my lords. Let it be there in the list. So I'll make. Serial number 61. It's an
Oh.
election matter, my lord, because administrator was appointed in November 2023. Election is not been conducted. The question before this honorable court was, the election should be conducted within 6 months from the date of appointment of the administrator, which they have not done. And they have given the schedule. They have given the schedule to complete the election in the month of October.
So
That consideration is pending, my lord, sir. So that consideration is pending, Mr.
Very
Ravishankar. Sorry.
why you are mentioning that?
I heard all office objections are urgent, so that's why I'm making my submission. It's a serial number 61.
You have not said any about this matter.
Sorry, my lord. Apologies.
What do you want ultimately?
No, I'll wait for the, I thought the serial number 61 is urgent, so that's why I made my submission. Sorry, my lord.
Serial number 52, my lord. Only after 2 weeks, my lord.
I appear for the petitioner in serial number 52, your lord.
For respondent. Personal inconvenience, my lord.
So what do you want?
Adjournment.
Why?
Senior have some personal inconvenience.
Contempt what senior will do? We have to do
We
whatever.
already complied, my lord. Learned civil judge.
Comply with them, don't seek time. Let it be called off. We'll see.
Serial number 42, my lord.
You are for whom, madam? Complainant?
Petitioner, please, for the complainant, yes.
So what is the complied with or not compliant?
No, this is an order on visitation rights, your
Oh,
lordship,
acha, I see.
and 15 days have been violated. We were given 30 days
So
time.
then
to
they
spend with
seek
the
time, any objection to time?
If there is a personal inconvenience, it may kindly be listed next week.
26th.
Much
Lord,
obliged.
serial number 5, my lord. Serial number 5, I see.
5, yes.
5, serial number 5.
What do you want?
2 weeks.
2 weeks. 5?
5.
1 second. All right, 2 weeks.
Serial number 42, my lord. Serial number.
Press might be circulated. No memo is necessary. Yes.
Serial number 42, my lord.
42.
Yes.
Yes.
Senior not in 1 week.
Why?
Already it's not to respond.
All right. Then 2nd July.
Serial number 55, my lord.
55.
55. The matter has been settled between both the parties out of court through an MOU, my lord. Filing the memo of withdrawal.
That is withdrawal.
Yes, my lord.
Learned advocate, Mr. 50.
55, my lord.
55. Writ appeal number 150 or 23. Learned advocate, Mr. What is your good name?
Umapati.
Umapati, yes, for the appellant. appears and submits and tenders a memo dated 7/5/24. In which it is stated as under the court this memo. As the parties have settled the dispute outside the court as per the above memorandum, above memo, learned advocate for the appellant seeks permission to withdraw the present proceedings. The writ of appeal is disposed of as withdrawn in light of the above statement and the memo. Yes, next. This was 55, yes.
Luckily, which we filed the application to restore the appeal, my lords, because it was concomitant to office of the. My lords was on account of me suffering a motor vehicle accident. 3 weeks time was given. Complaint subsequently in the coming week, when we approached, we were told that.
Then file IA,
We filed, my lords, on 26/4, we filed the IA.
get it listed Monday. Monday and mention it in the beginning if it is lower in the board, yes. In accordance with the, to be placed before the appropriate bench in accordance with the roster. Item number 70.
To be mentioned, C number 1.
This matter was listed day before yesterday, my lords. I was told that the impleading application mentioned this matter for adjournment at 10:30 and I was not aware of that submission. But there was an undertaking given by the learned additional advocate general on 20th February. So because I could not make submission on its extension, my lords, it was adjourned without extension. So my lords, I'm requesting that it may be extended and listed in on the date given, my lords.
I have got objection.
It was given on 10/7. Because it was mentioned at 10:30, I was not aware, my lords.
Sincere
Writ appeal
apologies. I
comes
have taken
upon
the date.
pursuant to
I have got objection for the matter being adjourned. For the reason that
purpose
the,
of being spoken of, full stop. It was pointed out that in order dated 11/6/24, in order dated 11/6/24, the following words, following lines have been omitted to be transcribed. These are the lines. Undertaking given by learned. Here,
may I bring to the notice of the honorable court.
full stop. The above lines shall be incorporated in the order to be part of the order, and that the order shall be reissued accordingly.
In this matter, I wanted to bring to the notice of the court. The property as held by the learned single judge belong to Shumaga Mahanagarpalike, and it has been handed over to.
It is not for hearing. This is the only purpose why it was not.
The reason being,
But where you get, when it is notified, you submit. Today only for this correction of the order.
any earlier date, because the work has come to a standstill.
Date is already given.
My lords,
There
I
will be no
have
change
filed
in
the
the.
pleading application, my lord. Our work has been stopped. It's a cancer hospital.
But then you could have mentioned on that the 11th. You did not do it. Today it can't be changed like that.
An earlier date may kindly be fixed so that we will be in a position to show before
On
the court.
11th, it is already fixed to be 10/7.
10/7.
10/7 is too long a period.
You
Any
could have-
date earlier to that.
Could have requested on 11th of June.
Today we are making a request before
It
the
can't be
court.
made. We can't go on changing the order, judicial date given like that. This is only for the purpose of adding the line
10/7 will
for
be,
benefit.
10/7 will be too long a date because of the work has come to a standstill.
You could have requested on 11/6 when it was adjourned to 10/7. Now, when this today it comes up for correction of the order, you can't change the date like that.
It was my mistake, my lord. I have taken.
Then
the
file
date
IA
because I
for
have-
preponement. File IA for preponement, yes.
10/7.
It is only for the mentioning purpose, not for changing dates. Yes.
This is for Education matter, seal number 2. Yatish.
I fear, my lords. It's a matter pertaining to the overseas citizen of India, my lords, to be treated as a citizen for the admission of my lords, medical and engineering, my lords.
So which you are challenging some rule?
Please, my lords.
Where is that rule?
My lords, Rule 5, my lords. What is under challenge? With Rule 5, my lords, eligibility of a government seat.
Rule 5,
Please, my lords. Eligibility of a government seat.
page
Page
624.
625, my lords, which I marked.
624. No,
625, my lords.
where is rule?
624, my lords, it's in the flagged it, my lords. Eligibility for the government seat. No candidate shall be eligible for the admission to the government seats unless he is a citizen of India and satisfy any one of the following conditions, namely, my lords, all the other conditions, my lords, we follow. Only with respect to, my lords, unless he is a citizen of India, my lords,
Which course?
my lords, MBBS as well as the engineering, my lords. MBBS as well as engineering. Lords, with respect to this particular subject matter, my lords, Honorable Apex Court has decided the matter. My lords, permit me, please. Para 54, my lords, in the last page, page number 23 onwards, my lords, is the observation. It relates, my lords, on the notification dated 4th March 2054 onwards, my lords, is the relevant portion. '57, my lords, is irrelevant. 57, my lords.
57.
Therefore, the 57.
Yeah.
Therefore, in the factual background of the issue involved, sum up, it will have to be held that though the impugn notification dated 4/3/2021 is based on the policy and in the exercise of the statutory power of the sovereign state, the provision as contained therein shall apply to the prospectively only to persons who are born in the foreign country subsequent to 4/3/2021. This is what the differentiation which has been done, my lords. Who are born on subsequent.
Controversy.
My lords.
Before the Supreme Court, what was the rule?
My lords. Pardon me.
Before the Supreme Court, what was the rule?
My lords, which points?
Judgment you are relying on.
Please.
What was the controversy in that case?
My lords, similar circumstance.
Very that. That is, which rule was involved in that bit?
My lords, Para 1, my lords.
Para 1. So,
the petitioners in these petitions are the overseas citizens of Indian card holders, where similar to the petitioners. They're all the students who have just reached the full age and below the age. All the petitioner aspiring to become a doctors by pursuing a MBBS course by securing admission through NEET select process and thereafter the post-graduation as also the super specialty in the field of medicine. Some of them are also seeking to pursue the post-graduation also super specialty for the purpose of the narration of the fact the government put forth in WP so and so, which was taken to be lead case is noted. As per the power conferred, my lords, as section 7(1)(b), 7(b)(1).
Yes.
My lords, as per this power, my lords, emphasized as per section 7(b)(1), my lords, notification was issued. But my lords, while issuing the notification, it was said that it did not expressly said that retrospective effect. Hence, my lord, the Supreme Court has,
That notification.
my lords,
What was that notification?
my lords, notification stating that, my lords, OCI cardholder should be treated as in par with NRIs for the admission process.
For respondent number 1, Union of India, the notification is issued by the.
My lords, considering the same, my lords, considering the Supreme Court, my lords, the coordinate bench has also passed an interim order.
Where is the notice?
My lords, interim order, because my lords, identical matters, my lords, more than 30 matters are there, my lords. In identical matter, my lords, the similar order has been passed, considering all this aspect, my lords. Hence, my lords,
Where is that order? Identical.
my lords, the same interim order which I have passed now. Please, my lords.
It is in, let us. You just
And it has been passed on the,
appear on Tuesday will consider, Wednesday will consider, next Wednesday.
please, my lords, let there be a liberty, my lords, to me to serve on Mr. N.K. Ramesh who appear for KA. Well, Mr. N.K. Ramesh appear for KA, my lords, respondent number 3.
Little louder, what I say.
My lords, for respondent number 3, Mr. N.K. Ramesh appears, my lords. I will serve on him, my lords, permitted.
Or learned educated for one session. Notice returnable. By interim order, the whole petition is allowed. This says. How can it be? Notice. Wednesday will be 19.
Please.
Learned additional government advocate. Nilofer Rathwar, as well as learned advocate.
Respondent number 1 already appeared. I already appeared. My name is shown in the passage.
What
For
is
respondent
good
number
name?
1.
You are not telling to me.
For respondent number 1, I already appeared, man.
You
For
are not
Union of
willing to
India.
tell your name to me.
BM Kushalapam. Sorry. No, it's already shown in the list. man.
So and so respectively. For respective respondent, where except notice. Rest of the respondents shall be served.
Madam.
Notice for respondent number 2.
2. And you, Mr.
For respondent number 1, my lord.
1.
I'm for respondent number 3, my lord. I'm for respondent number 3, my lord.
3 who is there? 3 also.
Well,
I'm
3,
for-
Mr.
it's
N.
3, ma'am.
Ramesh's colleague takes
You want to tell your name or not?
your
I'm
name.
for
Your name.
Raghavendra PH, my lord. Raghavendra PH.
Obligement.
Number 3,
Please.
Hanumanta Parigowda.
This honorable court of hearing directly to the instructions in the matter belong. What you assured on the government advocate announced.
My lord,
Second round discussion without. Court sponsors the order. Annex the point of page number 51. Opposite question without page 52. Second parameter. The protest is the form. Appearing on responding. Second time, special counsel is made for Hyderabad, Karnataka region under Article 371A of the Constitution of India. A separate site, development board is already created for state region. Second site, the equitable allocation of funds for developmental expenditure over the state region is also being made. This spreadsheet disposed of recording sections, recording developments subsequent to the report of the Dr. D. Committee.
So there is already, so what is the relief you are praying for? What is the prayer?
Representation.
Where is it?
Page number 58.
Page number?
58. 58.
my lord, may I make one submission? My lord, on the last date of hearing, my lord had called upon me to verify whether the recommendations made, my lord, by the Dr. D.M. Nanjudnappa committee, my lord, report was being implemented or not. My lord, it is being implemented right from 2007, 2008. Yes. My lord, I will file a memo. The memo is ready. If my lord could have it on Tuesday, I'll file a memo along with the annexures to give a quietus to this list, my lord.
What do you want? On Tuesday you want with cost or today without cost? Frivolous petition. On two counts. Councils of the government says that it is being implemented, number one. Secondly, similar direction was given as back as in 2014 by the court in another writ petition 44740. Again, you are filing the same petition without verifying whether it is actually implemented, what is the status, what is the state of affairs. You just go on throwing the PIL. Like, so choice is yours. Will grant time to the counsel for the government to file the counter, to keep the petition on Tuesday, to be dismissed on that day with cost, or today to be dismissed without cost. No. In a very cryptic petition filed in the nature of, in this style, in a very cryptic petition filed, styling as public interest petition, the prayer is made that the representation of petitioner for implementation of the recommendation of Dr. D.M. Nanjudappa committee should be decided. Also, the petitioner claims, as per Everman, himself to be as public spirited, spiritual, spiritual and energetic person. Post of. When in course of the consideration of the petition today, learned additional advocate Ms. Nilofer Akbar, equipped with the instructions, submitted that the committee's recommendations are already implemented
Are being implemented.
and are being implemented.
Yes, my lord.
Full
Every
stop.
year there's budget
Court
allocation.
records the statement. Full stop. This answers the petition. Not only that paragraph. Similar prayer was made in writ petition number 44740 of 14, in which order was passed by the coordinate bench, dated 19th September 2014. Full stop. Don't write that last full stop. In view of the above, no merit is found in the case and the grievance of the petitioner. Petition is dismissed.
Right.
This is number 4. It's a green bench matter.
Peti-
The Ramana MBD.
Appearing for the petition in this matter, my lords. This is a matter, my lords. Actually, on 14th February 2020, itself was disposed of as not maintainable. The Honorable Apex Court in some other decision has passed an order that should be re-looked into. And actually, I have returned the papers also. It's more than 2 years. I have only the writ petition in my system. I don't have anything. It's a very simple matter, my lords, where the petitioner had questioned regarding the classification of fish processing industry, whether it's under orange category or green category.
Yes, Supreme Court's order is.
Lord, he is not the party to the petition. He is not the party to the petition.
I have not prepared any SLP.
No, Supreme Court said that we have perused the impugn order. It must have gone from this proceeding only. Find that the order decides nothing on merits. It is therefore obvious that the writ petition filed by the petitioner will have to be decided on its own merits, subject to just objections which may be raised by the respondent here.
With due respect, Lord, I fail to understand. The Sundari Pujasi is not neither a petitioner nor the respondent in the present petition.
Here. So how come that this order is part of the record? You are for?
Please, I am for the private respondent number 5, man. Respondent number 5.
Who is for the petitioner?
Petitioner.
I am for the petitioner, my lords.
BC.
I have not filed any SLP, my lords,
Yes, Mr. Counsel.
because I have not prepared any SLP. That matter is closed.
Yes, what is the matter?
That's in this matter, they have challenged the issuance of consent to respondent number 5 by the Pollution Control Board. That's the list, my lords. That's the only prayer, my lords, which my lords will find it at page number 12.
So this
The
Sundari Puja
Pujarthi.
figures nowhere.
Nowhere.
She's
No,
not.
she is not a party in my matter, my lords.
But the subject matter dealt with by the Supreme Court was same consent.
My lords, it up.
It shows the same writ petition number in the order.
Seems to be like
Obtained by not
by a
properly,
third party. It's
not properly
non-party.
informing the Supreme Court. It appears. There is no petition filed.
Even before the Supreme Court, the petitioner here was not even arrayed as a respondent.
Now this order is produced by whom? Petitioner is not here.
Not here.
Yes, Mr. Counsel.
Petitioner is here.
No, I have not prepared any SLP, my lords. I am satisfied with the order passed by this honorable court.
So why come?
I have not
that,
prepared it. No, I have not prepared. Sir,
Lord, may I make one submission, Lord.
But then his order is set aside. 13th February. But this order is passed in this 1681 only.
Yes, it mentions so.
Well, that's
Lord,
the
it also mentions, Lord, the writ petition filed by the petitioner will have to be decided on its own merits.
Then either of you go to the Supreme Court and get clarification. Or we'll abide by this. We again afresh say, because this order is set aside. 1681 order earlier passed by the coordinate bench is set aside. Rightly, wrongly, at the instance of some stranger party, we don't know.
But the petitioner is not aggrieved by the Lord.
Petitioner,
Dismissal of this.
then
I am satisfied with the order, my lords.
Then withdraw the petition. If you are satisfied.
But
was
it,
already- Are you?
I'll
if
withdraw
you're
the petition. I'll withdraw the petition, my lords. I'll
withdrawing?
withdraw. That is the best solution. I'll withdraw it.
Is it okay?
We have.
Very good. You are finally withdrawing?
Yes, my lords.
With sound mind, unbiased mind.
No, that's why I made submission, my lords, that I am satisfied with the order. That's why I have not prepared SLP anything. I know that I have seen the order.
Are you complicating or solving the complication? Anyway.
No, I want to solve the issue, my lords. So that once it is.
Advocate, Mr. What is your good name?
MBB Ramana.
So and so appears through video conferencing to submit before the court that the petitioner is satisfied with the order. Oh, petitioner is not interested in prosecuting the present petition. He seeks permission of the court to withdraw the petition upon instructions. Permission is granted, the petition is dismissed as withdrawn.
I will file a memo to that effect.
Yes, very good.
Pleasure.
This 5 addend, seal number 6, Mr. Ashok B. Mulge. My lords, I appear on behalf of Sri Ashok Mulge, my lords, through
None
VC.
of the advocates appearing for the respondents have objection to the withdrawal of the petition.
My lords, in item number 6, my lords, I appear on behalf of Ashok B. Mulge, my lords. My lords, I seek pass over at 2:30, my lords. Due to some inconvenience, he has not at 2:30, my lords, kindly.
This writ petition, my lords, is filed seeking a writ of mandamus, my lords. Seeking representation which they have placed before the government and the pollution control. Wide annexure P and M1, my lords.
My lords, I am proxy, my lords. That's why I am seeking pass over at 2:30, my lords. He will appear at physically, my lords.
Then some other, it may go to some other day. Fine.
prayer is to consider represented.
We will do that.
But the second part of the prayer maybe.
Second part of the prayer cannot even be granted without your reply. Let him come to the.
Oblige, my lords.
Seal number 7, writ appeal matters. The Mansi Kumar.
I appear for the appellant's counsel in writ appeal 242, my lords.
236.
There are two appeals listed before my lords today. The first appeal, my lords, is filed by the private party, my lords, and the Union of India has also challenged the learned single judge's order, insofar as it sets aside the appointment of the chairperson of the National Commission for Homeopathy. That is the short compass around which this issue revolves. I may just take my lords through some. A few relevant dates, if I may take my lords through. I'm sorry, Mala. That's right, Mala. Absolutely. That is the short issue. If I'm a lead, I believe I'm a leader, my lords. In fact, more importantly, the Union of India believes I'm a leader. It doesn't matter what I believe. The union has appointed me. Yes, ma'am. The first one. Yes, ma'am. Yes, ma'am. I appear for the person whose appointment was set aside. Yes, ma'am. That's right. Yes. Ma'am. The Union of India, ma'am. That's right, ma'am. That's what the issue is, whether I was a head of department or not. And just to give an overview of what I would seek to submit, that the learned single judge, my lords, had called for the record. My lords may turn to page 73. Page 73 is the, in fact, starting at page 71, the statute has been extracted. Page 73 is the relevant provision. My lords, at section 4, the commission shall consist of the following persons, namely a chairperson, 7 ex officio members, 19 part members. The chairperson shall be a person of outstanding ability, proven administrative capacity and integrity, possessing a postgraduate degree in homeopathy from a recognized university, and having experience of not less than 20 years in the field of homeopathy, out of which at least 10 years shall be as a leader in the area of healthcare delivery, growth and development of homeopathy or its education. Now, on the next page, my lords, leader is defined. Explanation. For the purpose of this section and section 19, the term leader means the head of a department. Page 74, my lords, explanation, right on top. Page 74, just below the proviso. The term leader means the head of a department or the head of an organization. Now, my respectful submission, my lords, would be that the Union of India, my lords, called for applications. My name was proposed by the search committee. In fact, even the cabinet approved my appointment after a thorough examination of all the records. Now, my lords, the learned single judge, I would respectfully submit, has taken a more myopic view and said head of department means you have to be a director or a so-and-so. But, my lords, if a purposive interpretation is given to this term, now, eventually, my lords, the intention of this provision is to ensure that somebody who has capable administrative experience is appointed as the chairperson, and he has to have, out of 20 years, 10 years experience as a leader. Now, my lords, a very strict interpretation would lead to rather ambiguous results where, now, if I have 10 years experience as a principal of a college which has 10 teachers, I could be the head of a department, I could be a leader, as opposed to me being, say, an assistant director, as I was in this case, where I have more than 100 people working under me. So therefore, a more purposive interpretation ought to have been applied, particularly in light of the fact that the union thought I was fit.
Fine. Committee will consist of this. Secretary, experts.
Page 33, my lord. Yes, my lords. No, I don't think there was any. Correct, my lords. Absolutely. No dispute regarding that. Yes. Yes, that's it. I think about 2 years, maybe. This is, my lord, CCRH is the Central Council for Research in Homeopathy. Yes, ma'am. Yes, ma'am. Correct. I quite see that, Mars, but my respectful submission would be that yes, but the small, I understand, it's a very small window I have. The small window, my lords, is when the section says that a person shall have experience as a leader in the area of healthcare delivery. The object of the provision is to ensure that not only should I be an expert in homeopathy, but I should also have 10 years of administrative experience. So I could be a very good doctor, but I may not have administrative experience, for which I will not be qualified for this post. So therefore, out of 20 years, 10 years, which is why, Malas. No, my respectful submission, Malas, is what the section requires is this. Once it requires 10 years experience as a leader, and leader, I admit, is specifically defined to mean head of a department or head of an organization. Yes, Malas. Now, my only submission is, and I understand it's a very small window, is where when it's defined to mean head of a department or head of an organization, the section, if it is read in an extremely myopic manner, would mean only one would be going by the nomenclature of the post rather than what the functions that he has performed. Which is why, my lords, in fact, at page 48, if I may request my lords to kindly see page 48 of the paper book, where the learned single judge has noted. In fact, possibly the union also had this doubt as to whether I'm qualified or not. Kindly see at paragraph 40, my lords. The argument that a specific opinion was secured by the search committee regarding the eligibility of Dr. Anil Khurana, and an opinion was also rendered that Dr. Anil Khurana had the requisite experience of 10 years, equivalent to the head of a department, to that of a head of department, and this opinion is required to be accepted, does not merit acceptance. It is no doubt true that in the original records that were produced, there is a communication dated 6th of May 2021, which indicates that a clarification was sought regarding the eligibility of Dr. Anil Khurana, and the scrutiny committee examined the application of Dr. Anil Khurana and observed that he may be eligible subject to submission and verification of documents of experience as the head of department from the competent authority, cadre clearance, and the certificate of not having a major or minor penalty against him. It is also stated therein that the Secretary of the Government of India had got the matter examined in the Ministry of Ayush, and after verifying the documents of experience, it was confirmed that Dr. Anil Khurana possessed the requisite experience of 10 years equivalent to the head of a department, and therefore fulfilled the eligibility requirements for the aforesaid post. So therefore, my lords, the union itself has sought an opinion, possibly it had a doubt on my qualification, and it received an opinion saying that I possess the requisite qualifications of a head of department. So therefore, I fall within the scope of the explanation, which specifically defines that only a head of department is qualified. Now, my respectful submission, my lords, would be that once the union has sought an opinion and has thereafter appointed me after careful examination, whether the learned single judge ought to have gone into the merits or otherwise of the appointment while exercising jurisdiction under Article 226.
Lord, Lord, let me make my submission. Lord, there is no doubt that the leader has been defined to mean head of a department or an organization. Lord, here, Lord, we sail with him.
Both of them. Yes,
there, my submission would be, my lord, we cannot go by the literal meaning of department here. Not everybody would follow the literal meaning. The department would mean making a distinct category. Now, for example, there could be an institution where there could be Department of Biology, Chemistry, Physics. In CCRH, that is the Central Council for Research of in Homeopathy, they have not made any watertight department, but they have distinct responsibilities. And the writ appellant, the petitioner, no, in this council, there was no departments as such. In the CCRH where he was employed between the period 2008 and 2000 till the date of his appointment as the chairman of the commission. That particular council did not operate in watertight departments. I'm sorry, he joined the council of the Central Council for Research in Homeopathy on 16th of May 2008. He joined as assistant director. But nevertheless, since there are no departments, he was given responsibilities which a head of department would. If we had, he was given responsibility of research and training. If at all that particular council had a department, it would have called Department of Research and Training. So can we go by literal meaning and deny him the opportunity? The search committee, which comprises of the cabinet secretary, 2 eminent people who have 25 years experience, reviewed all this, and in their wisdom, found him to possess leadership quality of someone who would have headed a department. Now, the question is, can the wisdom of that committee be replaced by a learned single judge under the exercise of his jurisdiction under Article 226? Learned single judge has gone on the literal meaning of the word department. He says he was an assistant director. Therefore, he was not the head of the department.
He was the technical head.
What would help is the expression department is not defined in the National Commission of Homeopathy Act. In the absence of a definition of department, then Lordship will examine whether there are any sections or responsibilities. This particular officer was given the various responsibility of heading the training, research, all of which he has discharged. So, once again, the expression head of the department will have to take color from the word leader. Leader would mean, as he demonstrated leadership quality in handling certain responsibility, as he single-handedly handled the responsibility that was given to him, a distinct responsibility. The council had given him the distinct responsibility of managing the training, seminar, conducting research.
Technical head.
Actually, he acted as the technical head. There was a technical section under the Central Council for Research in Homeopathy. He handled it independently. Although, in terms of his hierarchy, he may have been the assistant director, but he headed the technical section. Therefore, the committee found that he had leadership, he demonstrated leadership quality, and he acted as though he was the head of the technical department. That the learned single judge could not have dismantled by exercising powers under 226.
The requirement is he should be a leader for 10 years in the area of healthcare delivery. The word leader is clearly defined as a head of the department or head of an organization. Now kindly go to page 294, my lord. Where we are working is makes it clear. Page 294. Now he joined as a research assistant, not as assistant director, as my friend said. Page 294. The curriculum. He joined as a research assistant and he was the assistant director from May 2008 to June 2014. Now it requires 10 years to be the leader. He was not even the deputy director for that period. He was deputy director only from 2014 to 16. and then Deputy Director General from 16 to 19. Now, if we go back to 10 years, the 10 years period, he was only an assistant director. Now, the working chart of this organization is found at page 433. We go back to 10 years, Flood, he was only an assistant director. The different designation in this organization is at page 433. At page 433, my lord. Volume 2, yeah.
Volume 2, I think.
ಹಾಕಿದ್ದೀರಾ ಈಗ ಕೊಡ್ತಾ ಹೋದ್ರು ಪ್ರಾಬ್ಲಮ್ ಇದರಲ್ಲಿ ಇದೆಯಲ್ಲ.
Sorry, what? I have filed an appeal and so has the union. Union has also challenged. I'm for the appointee, my lords. Yes, and the union has also challenged the learned single judge. We have also filed it.
Well, there is one cross objection at serial number 10 in the same appeal. What the learned single judge has said to once again ask the search committee to conduct first selection. Our request is among the persons who have already been selected in the search committee that could be considered. As a director, Lord, now afresh, entire selection to be done afresh. That is.
No, man.
What they say is that afresh selection to be done afresh. Huh?
I'm told that Mr. Janardhan's also was subsequently, I think,
That is
subject matter
also
review.
subsequently set aside.
Although his appointment is upheld in this order, subsequently reviewed, but that doesn't, it's unconnected with this.
Only with regard to this conducting of selection afresh. But
Yes, ma'am. But no, it's not stayed, it's not stayed. It wasn't stayed even during the pendency of the writ petition. For
now
writ
the
petition was
total
filed-
term is 4 years. Now almost 2.5 to
One more year left, like almost exactly a year left.
1 year is left.
July 2025, the term.
ನಮ್ಗೆ ಅದ್ರಲ್ಲಿ ಕಾಪಿ ಸಿಕ್ಕಿಲ್ಲ.
ಯಾವುದು?
ಐಟಮ್ 10 ಅಲ್ಲಿ ಸರ್ವಾಗಿಲ್ಲ.
ಕ್ರಾಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಲಿಸ್ಟ್ ಆಗಿದೆ. ಸರ್ವಾಗಿಲ್ಲ ಒಂದು ಕ್ರಾಸ್ ಅಬ್ಜೆಕ್ಷನ್
ಕೊಡಿ. That's the only point.
That is the only
That's the
point.
only point.
And in this chart also, my lord, he was working only as an assistant director.
Lord, the question would be, in the absence of a definition of department, Lord, what meaning should be ascribed to it?
It is there. Definition of department is also available in the government, central government. According to the
No, in the
central
National
government
Commission of Homeopathy Act, there is no such.
manual of procedure is there in the central government.
And also, the purpose of interpretation would avoid any incongruous results where I could be principal of a college with just 10 teachers under me. I will then be qualified, as opposed to me being, even if I'm assistant director, kindly see in that very same chart, kindly see the number of people who report to me. But keeping the object in mind.
Now, we have to go back 10 years. 10 years, you were only assistant director. Only at the fag end, he becomes. One point, my lord, at page 419, the definition of head of department is according to central government manual, is defined at 419, my lord, in the rejoinder I have extracted.
Again, second volume. Second volume.
Page 419.
General financial.
Rejoinder, para 4, further the definition.
General financial rules.
Head of department as defined under the general financial rules reads head of department means authority or person not below the rank of deputy secretary to government of India, declared by the concerned department in government of India as head of department in relation to an identifiable establishment or establishment to exercise delegated financial power under these rules. No doubt it is under the financial rule.
But I don't think
But
this would
it has
have
to be
general financial rules.
No, it applies because this is, one has to understand having regard to the meaning which the central government itself gives. And he was working only as an assistant director, below deputy director. Thereafter, he gets promoted as deputy director. In the same page, my lord, at page 400, in his own he was in his own remarks, my lord, in his own service records at page 400. It also says, page 400, recommendation for career advancement, rewards, incentives.
Yes,
That
ma'am.
is
That's
the
the
only
only point.
point.
If my lord's permits, we'll hand over some judgments. We'll hand it over to the court officer during the course of the day. Very well, ma'am. We'll do that.
Blood serial number
With the
10
list
also.
of dates also along with that, we'll. With the para numbers also, absolutely. With the para numbers, everything.
Serial number 10 may be tagged on with this matter, my lord, because that is only my cross objection, limited cross objection. Instead of fresh selection. No. We are not there in that.
Don't be there.
Which page?
has to have some other 450. 523. We'll just make this a separate compilation, put para numbers. And ಓಡ್ಬೇಕು ನೀವು. Synopsis department is not defined. The CCRH does not have any water treatment department. However, he was given responsibility of taking care of the entire technical section, which has been examined by the search committee. And in the wisdom of the search committee, single judge cannot replace the wisdom of the search committee. It will benefit one day. Relevant para. By Tuesday, my lord, the synopsis will be Tuesday. Grateful.
That serial number 10 cross objection also, my lord. serial number. That I'll produce, that.
No, Tuesday, my lord, Tuesday.
No, Tuesday only, that serial number 10, my lord. That cross objection can also go along with this. Separately listed. Serial number 10.
Grateful.
Yes.
Seal number 8.
That
Anish Acharya.
appear for the appellant's counsel. That petition under section 95 of the IBC code was filed. That order impugned is filed along with the memo, because when we filed the writ appeal, the order was not there. Subsequently filed along with the memo. When we filed the writ appeal, pardon me? When we filed the writ appeal, it was not uploaded. Subsequently, along with the memo we have filed, there was office objection and it is overruled by this court. It is there, my lord. There was office objection regarding that and it is overruled.
Probably at page 708, not at the end of the paper book.
That there was office objection regarding that, it is overruled by this court, my lord. But when we filed, Lord, what has happened is this, my lord. But when we when we filed the writ, I know, my lord, when we filed the writ appeal, yes, there is some urgency. My lord, I will do that. There is some urgency. There is some urgency, my lord. The arbitration proceedings are going on almost on day-to-day basis. That's why, my lord, this matter was moved almost. Yes, problem. Yes, we'll do that. We shall do that. We apologize for the. Yes.
Seal number 9.
The council be permitted, my lord, to do that, my lord. Otherwise, my lord, the pending branch may not allow to do that. Greatly obliged. Greatly obliged.
Also supply a repaginated copy so that we could also assist you.
The council on record, well, yes.
Seal number 9.
Appearing for the appellant, my lord. This is the appeal against the order of the learned single judge, my lord, wherein the learned single judge entertained the petition, even though there is an alternative remedy for the petitioners, my lord. Under section 49 of the act, my lord, there's an appeal provision against the order. Please, my lord, but the order is challenged after 1.5 years, my lord. But as per the report of the order also, my lord, no objection was collected from all the villages. Notice was issued to the petitioners also, and no objections was collected from thereafter. Since the diversion was granted, my lord, that it was. Please, my lord. My lord, kindly see the order of the diversion of the Nala, my lord. There the authority has given all the notice to the villagers. After taking the no objections, my lord, the diversion has been done. Since the Nala was passing in the middle of the, now there is a already constructed, my lord, the building is there is a multi-storied apartment, my lord. I understand if the petitioner had come on time and and my lord, notice, my lord, try to see that if a notice has been ordered, my lord, can be settled whether the my lord, the court commissioner may be appointed, my lord. There is no but if the order is in view of the interim, in view of the impugned order, my lord, they are putting up construction in the property without waiting for the authority to decide the matter. That is my difficulty, my lord. I have no objection to if notice and if the maintain status quo, my lord, if the building is come up, no purpose will serve before the authority, my lord. I have the photograph, my lord, which show they are putting up construction in the diverted portion of the Nala. This My lord, till the disposal of the status quo, my lord, in view of this thing, my lord, they're putting up construction, my lord. Till the disposal of the proceedings, I'm ready to face the proceedings, my lord. There's no difficulty, my lord. Till then, not to put up any.
Then reserved seal number 11, the B. Vidulata.
For the accused in this matter, Your Lordship. Your Lord, this is the matter where the direction, where the divorced daughter, Your Lordship, may kindly have it at 2:30, Your Lordship. We'll comply with the order. 2:30, Your Lordship. Today, 2:30.
Today, your lordships had directed them to comply with the order. They're saying 2:30.
My learned friend said that there's a difficulty tomorrow.
Today or tomorrow, whatever. Compassionate appointment, my lords. They are rejected on the ground that she's a divorced
Divorced
daughter.
daughter.
This honorable court, my
View
lords.
of
on
this
two-
order, by 2:30, we'll issue the order. Yes, Your Lord.
Please. Yes, my lords, please.
Regarding consideration of complaints in contempt matter, seal number 12.
For complainants, no, sir.
Complaint affidavit is filed in this matter.
It's encroachment of public street. PIL, this court passed an order, annexure A, page 10.
We have complaint, we filed a complaint of.
ಏನಾಗಿದೆ? ಏನು order ಮಾಡಿದ್ದಾರೆ?
Page 16 is the order, Your Lordship. Page 16 is the order. Page 16, Your Lordship, of the contempt petition, if I may read. The order said, considering these facts, we are of the opinion as the process is initiated by the respondent number 3 by taking proper steps. The petition can be disposed of with the only direction to the respondent number 3 to see the process initiated by him reaches to its logical end by following the provisions of law, and respondent number 3 shall make any endeavor to complete the exercise as expeditiously as possible.
Notes, this is not a compliance, notes, what they have produced a document. Subsequent to this order, my lords, after lordship have passed this order, the respondent number 4 and 5, they came up before this court. Along with my lords production of document, there is a further order by this court directing the Tahsildar to clear this encroachment by 11/3/24. Not this document which they have produced today, 13/3/24. No, does not indicate of any compliance, notes.
The
They
case
say
is-
they have received a application from the encroacher to consider the representation. They are considering it.
The whole issue arises out of the encroachment on a common pathway which is dormant as of now. Now, Your Lordship, they
Complaints.
we've already filed, Your Lordship. It's filed. It was filed on the 8th of April 2024.
24.
Para 4 of the affidavit. Para 4, Your Lordship. Page 2 of my affidavit. Notice of eviction, Your Lordship. They have appeared, Your Lordship.
Then what happened? You are supposed to take it to logical end.
Yes, Your Lordship.
What
Now, what
did
has
you do?
happened is, Your Lordship, there is an encroachment that they've all constructed. Not only this respondent, but there are other 3 houses that have been constructed on the pathway which has become dormant. It is not used henceforth. In fact, whatever the allegations that they have made, that there is they wanted to access to the dairy. The dairy is situated on the national highway itself, and there is a national highway which approaches to the dairy. Now there is some, the fact is, Your Lordship, there is some ill will amongst these people, and only to harass the other person. Now, as per that, he has also given an application for an alternate pathway, and he is agreeable to release his own land for the pathway, to retain that pathway, Your Lordship. That application is pending. And also there is a provision under the Karnataka land grant rules to allot an alternate pathway, Your Lordship. Now, the only issue is if we engage into this demolition, they have been in possession from past 30 years, 4 to 5 houses have to be demolished, and the public will be put to a lot of hardship, If at all the grievance is that he requires a pathway, then he is willing to give an alternative, and he is given an undertaking and also filed an application. Now that application has to be considered by the deputy commissioner, because the Tahsildar has no power to dispose of the application for the alternate pathway, as provided in 28A of the land grant rules. There is
logical answer. Eviction. They are supposed to evict.
Not kindly see notes at para 4 of the order of your lordships, page number 15, my lords. Your lordship have considered all this. Tahsildar, in fact, not obtains a report from Lord's Assistant Director, Land Record Survey Department, confirms there is an encroachment. And he himself, Shivameto, takes action under section 149A of Karnataka Land Revenue Act. Now he wants to contend before this court, my lords, that irreparable hardship injury will be caused to a violator who is an encroacher in a pathway.
So you are supposed to read paragraph 6.
Yes.
Number 3, to see that the process initiated by him reaches
a logical end.
To its logical end, and by following the provisions of law, and number 3 shall make an endeavor to complete its experience. So this is your to do. How it ends, we are not concerned. It must reach the logical end.
The opportunity was provided for all the people who have.
You are not understanding, Mr. Council, what we are suggesting.
Yes, sir.
Or we are driving it. Where we are driving. We will grant you the 2 weeks time, within which time it should be taken to logical end. Otherwise, the Tahsildar will be here. Yes. While the compliance affidavit is sought to be filed, and it is explained that the order is compliant with, the court is not satisfied with the compliance, as the order, as the directions of the learned single judge requires its owner to to see that the process initiated by him reaches to its logical end, END, by following the provisions of the law, and that the respondent shall make an endeavor to complete the exercise experience. Full stop. To be listed next on 5th of. To be listed next on 10th of July. On that day, that day, learned additional government advocate, Mr. Jafar Shah, would apprise the court about the further progress and the development in carrying the process initiated upon eviction notice to its logical end. Initiated pursuant to notice to its logical end.
Number 13, Vasant Kumar HD. I'm the complainant in this case, ma'am.
So what did you do? Your compliance?
DVM.
You are not the party to comply. Who will be compliant? Who will be compliant?
DVMP.
You don't know. The college. Who will be complying the directions? Where is it? Go and come with me. Catch hold of it. 2:30. Learned counsel, Mr. You are Mr.
Name.
Really?
Susan states that you will catch hold of learned. I will be catch hold. Will catch hold of him in what way? ऐसे पकड़ के लाना यहाँ. Keep it at 2:30. Wait, keep.
Number 14.
Lordship, in this matter on the 3rd, when the matter was listed, we had apprised that there is a stay application, vacation of stay application which is moved, which was listed on the 4th of June. Now, the order has come up by the Apex Court in which there is no vacation of stay and the matter has been listed for the after vacations. I'll just pass the order.
That order you showed last time, any further development?
Plus, if your lordships recollect, this was the same case where your lordships had intervened with the children and the parties in the chamber.
That's right, Lordship.
Plus, after acting upon the order and taking the custody of the children for
Then
3
let it-
weeks. Plus, I am not on that. It's only the expenses that he's supposed to provide for the
Lordship,
wife.
may
No
I add-
accommodation has been provided,
explain,
no
Lordship.
expenses. has
Your
been-
now clarification, modification, you go before Supreme.
Lordship, they have moved an application for vacation of stay, modification of the order,
Not for the
clarification of
expenses.
the order, and they vociferously argued before the Apex Court that we want these orders to be vacated. Court said we have read the entire file, we will not interfere, come after vacations.
That is
And
not
has
true.
given us 4 weeks time to file the reply.
That's
Lordship,
right.
my humble submission is one. The fact of the matter is that it's all clear that why this has happened. The issue is that she was caught red-handed. And
That
then
is
she,
not true.
let
I
me
don't
just
think that-
explain, let me
no,
explain the
that is
point.
not true. That is not
And
the
these
argument
chats
that-
were also read before the Honorable Apex Court. Lordship, my point is why aren't they wanting to resolve this matter? Why don't they want to settle the matter? Just because the children are not, they're dragging the children into this matter. Because she was caught, she took the children away. Now she wants the children with her. We want to resolve this matter. Why shouldn't they want to resolve it? This also fell from the Apex Court also.
The argument, Milords, the submission.
I
of-
have no objection if the matter is referred for mediation.
For your lordships.
I have no objection to matters for mediation. Even they made these submissions previously. They were so interested to go for mediation.
He
Why-
never came. Milords, he never came. My issue is,
Okay,
Milords,
let's go for mediation now.
Milords, my issue is she has not been provided with any expenses as directed by your lordship.
Lordship, I will
Or the
make a
accommodation.
submission. In the event, I have complied with the order in letter and spirit, Lordship. There was.
Order is stayed, madam.
Lordship,
Plus- plus
Lordship,
what-
I'll explain this
May I
point.
just-
I'll go a step further, Lordship. I'll go a step further.
Letter submit.
What?
Stayed.
Yes.
May I, Milords? After acting upon the order, what he does is, before that taking custody of the children, he files SLP before the Apex Court. Now, filing an appeal along with an interim stay application, he does not disclose that. On the 5th of May.
I'm
he
so
takes
sorry,
the-
Lordship. I made
Let-
all disclosures. They were not there in
I
the
think
court.
I should be allowed to complete.
Then I will also submit. Let's complete.
On the 5th of May, he takes custody of the children as per your lordship's order. It's only on the 10th of May he discloses that there is a status quo order issued by the Apex Court.
Court has granted stay order. We can't do it.
Yes, Milords, I do understand. But what about the expenses that
I will
your
explain,
lordship
Lordship.
had directed?
Also flowing from the order.
Milords,
That is also flowing from the order which is stayed.
the status quo is only with respect to the children that as on date 10/5/2024.
Lordship, I will give a solution to this,
Because
Lordship.
even the interim,
Status quo.
Milords, even he has produced it, Milords.
It was produced last time.
Lordship will have a look at the order.
Till the next date of hearing, the parties are directed to maintain status.
Maintain status quo, that is all. The children were handed over, obviously,
As
orally
on
they
date.
must have submitted that the
Status quo as
children
on
are
date.
handed over.
But what they are interpreting is they moved an application vacation of stay. Now these Apex Court is written in the order vacation of stay.
Today about the expense.
Lordship, I will explain that. I'm very grateful that point has come up. Lordship, the point is, they've written in the Supreme Court that on the 4th of May, they handed the children over. And since then, she's living in Goa. This is what her pleading says.
Not at all.
That's what I'm saying. Please read your pleading. I'll read the pleading, Lordship, what they wrote in the Supreme Court. Page number 8, I will just read, Lordship, how they are misleading the Supreme Court also. Just one line, Lordship. The respondent complied with the High Court order and took the children to Bangalore on 4th of May 2024 and handed over the same to the respondent as directed by the High Court. Furthermore, she left them at the petitioner's house and is staying in Goa herself in a separate homestay.
That is not Goa, that is typographical error. It is Bangalore.
Okay.
As per
Now
your
it's a
lordship's
typographical
order.
error. Lordship, the point
The
is,
homestay itself makes it very clear.
now in the Supreme Court, you say I'm staying in Goa. In the Supreme Court, they're saying I've been giving zero visitation when
Why
every
would
day
she
she comes
stay?
to the house and meets the children for 1.5 hours.
Milords, why
And
would
in
she stay
Supreme
in a
Court on
homestay in
affidavit,
Goa? when
In
she has
Supreme
her
Court
own
on
residence?
affidavit, she's saying I'm getting no visitation at all. And every day, 1.5 hours, she's in the house. Lordship, I am on the point. I have booked her the
Supreme Court
accommodation.
says that maintain status quo, so status quo for argument also. Your argument remains status quo.
Lordship, I want to point out.
As per his own submission, she is visiting the children every day for 1 hour.
Lordship, I'm making
You
an
can't
argument.
make any argument, nor we can listen to any argument. That is the meaning of status quo. Wherever the arguments ended, you maintain. In this.
Lordship, my only
All
point
said
is.
and done, when Supreme Court is seized with the matter.
Yes. But Lordship, we want the matter to be resolved. Why don't they want the matter to be resolved?
Any clarification, any modification.
They moved it, they've already
anything
moved.
For going to mediation, we are of the view that you go before the Supreme Court.
So
this,
even
in
for
view of the
mediation,
order,
Lordship, even for mediation, we go to the Supreme Court, Lordship.
524.
That's my
As per the
only
Supreme Court.
submission was a pair. This is only this thing that expenses be.
Sorry, 10/5/24, read with dated 4/6/24. In view of the order dated so and so, read with so and so of the Supreme Court in special leave to appeal. Under C number 10381 of 2024, since the subject matter is pending before the Supreme Court and the status quo order is granted, directing and the interim order is granted, directing the parties to maintain status quo. The present postings are required to be adjourned.
Plus, only
No,
the
Lordship,
expenses if the council can.
The next date in the matter is 9th of, tentative date in Supreme Court is 9th of July.
There is no
Tentative
date given.
dates.
Because there is no date given. I will move the matter. That's another thing. But if the council can tell his party to provide for the expenses, my lords,
Lordship,
that would be a great.
18th of July.
Lordship,
18th of July.
Lordship, 9th of July is the tentative date. She said there's not.
So we are keeping on 18th of July.
Plus, let it be a little earlier because 4th of June it has come up and 4 weeks has been granted for them to file their counter
Tentative
affidavit,
date is 9th.
which end-
Supreme Court is opening on the 8th of July.
Yes, that's right.
9th of
I
July
only
is the
asked
tentative date.
Your date, my lords.
Supreme Court is opening on the 8th of July.
Because they are not even providing the expenses and it is becoming extremely difficult for her.
12th July.
Grateful.
Just one second.
December 15.
May it please, Malad. Malad, I appear online, Malad. Malad, this is a PIL that has been filed for implementation of the provisions of the Sampurna Behura judgment, Malad. It's completely non-adversarial.
Figures other than 4% in this thing. Yes.
Malad, this is non-adversarial, Malad, regarding implementation of the provisions of the Juvenile Justice Act, Malad.
My lord, on this honorable court was pleased to pass an order on 19/12/2023, whereby, my lord, the state was directed to file a status report. That order has been reiterated on 25/3/2024. The state, my lord, may place that report on record.
We have placed, my lord.
Malad, that has not been done. But before that, Malad, would your lordships just refer to the order of the 22nd of July 2020 for a moment, Malad, and specifically para 30 of that order. July 22nd 2020, my lords. I'm raising a specific point of non-compliance. That's why I want to refer to that particular order, my lords.
Yes.
Yes, Manoj. Manoj, this is regarding social audit, Manoj. Manoj, the first submission is as regards social audit of the implementation of the provisions of the JJ Act. He has relied on, that I relied on, Section 109 of the JJ Act. Subsection 1 of Section 109 mandates that the state commissions shall monitor implementation of the provisions of the JJ Act. Thus, social audit of the implementation of the provisions of the JJ Act is contemplated to be undertaken by the State Commission. Moreover, looking to the observations made by the Apex Court, the social audit will have to be undertaken at the instance of the state government. The reasons being, even the social audit of the performance of duties and discharge of the functions by the State Commission will have to be undertaken. The state government, while filing the response, shall place on record in what manner it proposes to carry out social audit of the implementation of the provisions of the state. Manoj, we are almost about 2 years from that date, Manoj. Unfortunately, nothing has been done so far as social audit is concerned, and social audit is in fact required to be done every 6 months under the provisions of the Act. Manoj, I may say, Manoj, Karnataka is at the forefront of the implementation as far as the JJ Act is concerned. But if the Mool mantra or the core of Manoj, the performance is not done, that is the social audit, Manoj. I don't see, Karnataka being at the forefront at all, Manoj. All other states, Manoj, I can say it because I have appeared in the other states also, Manoj. The social audit has been conducted by all state commissions as far as other states are concerned.
What is the stage of this proceeding now?
My lord, the state has filed certain reports. The Karnataka State Legal Services Authority has asked the state to give certain, as per 13/2/2024, my lord, this Legal Services Authority has directed certain things from the state of Karnataka with regard to sanction post and effective steps taken by the state of Karnataka in funding and creating the Vatsalya Sadhana. So my lord, asked report we filed in 2023. After that, there are certain other steps that the state is required to do as per these reports filed. So
My lord, may please see my,
this is a matter of 2018, my lord, with regard to the effective implementation of the Act and the Supreme Court directions.
my lord, may please see the reply filed by the Legal Services Authority dated 13th March 2024. 13th March 2024. This, my lord, lays out the steps that were required to be taken by the state government. My lord would recall also the question of the Secretariat for the Juvenile Justice Committee. That was also brought to the requirement of the same was brought to the attention of this Honorable Court.
Manoj, I have not got a copy of that, Manoj. My learned friend may be pleased to give a copy to our council, local council there, Manoj. In all other states, Manoj, we have provided a chart as to the various directions that may be required. I can also provide that to your lordships, Manoj.
My lord, this Juvenile Justice Committee, this is point number 8. We are absolutely pleased to say, my lord, that the state government has actually now constituted the same, my lord, the Secretariat. They passed a government order. I was given it by the legal services, my lord. I just have these 2 copies. There. This, my lord, was at, my lord, may please see point number 8. This was something that was being reiterated by the Juvenile Justice Committee for the past 2-3 years, my lord. So we must place on record, my lord, our appreciation that the same has actually been done. Now, besides that direction, my lord, there are other 9 points, my lord, in regard to which the state has to file its status report, my lord.
So it is necessary to remain, keep it pending?
Please, my lord.
Is it necessary to keep this petition pending?
My lord, there are at least 8 other requirements for the proper functioning of the Juvenile Justice Act, which the Legal Services Authority has pointed out. For instance, my lord, even the appointments to the CWC and the JJB.
You just pin down the.
My lord, it is in this reply.
Malad, may I then make a small suggestion, Malad? I will come personally,
No, you
Malad.
are saying that
The Lordship will keep it next week sometime, Malad.
My lord,
I'll prepare a chart as to the various directions that may be required to be passed by your Lordships, Malad, for further implementation.
So prepare a chart, will help us.
Yes, Malad, we will do that. Lordships will keep it sometime next week.
So we take it, no, not next week, a little longer. You can
yes,
have your own.
My humble request in this matter.
The subject matter of this public interest litigation is the effective and purposive implementation of the juvenile justice laws. Full stop. Several orders have been passed by the court dealing with the subject and issuing directions pursuant to, not pursuant to, after institution of the writ petition, after institution of the public interest petition in the year 2018. So submitted today by learned regular parties that was submitted by making certain suggestions by learned regular parties that those suggestions are still to be gone into and should become part of the directions of the court. Full stop. Time is granted to either such aspects which may be needed to be addressed in relation to subject matter of implementing juvenile justice law and the Juvenile Justice Act. Full stop. Learned counsels may assist the court on the next date by submitting the appropriate chart,
Please, ma'am.
including chart or synopsis, as the case may be. Stand over to 22nd July.
Please, my lord.
My lord, my only.
Malad, if your Lordships can keep it in June, Malad, we have our vacations here. So I'll be able to come down, Malad, and assist your Lordships personally, Malad. It will not take much time. I'll just take 15 minutes of your Lordship's time. I'll build up the entire thing.
On the, we'll hear it. We hear you.
My
We'll
only,
hear you on that.
my only humble submission, my lord, is that there is 2 writ petitions in this, 2 public interest litigations, and a series of expectations from the state of Karnataka. So if the Legal Services Authority and the petitioner in the second petition can give us as to what we need to do, because each time we file a report, there's another set of requisitions they require. And the state, if we can examine it and see as to how to go about it, we could have it done comprehensively at one go, my lord.
For the Legal Services Authority, my lord.
So what do you want from them?
From 2018, my lord, there are reports being filed by the state as well as the Legal Services Authority as well as the petitioner in the second writ petition. So my humble submission is if they can give us a comprehensive requirement, then we could address it at one.
Please, my lord, that definitely can be.
In the chart that I will make, my lords, we'll compile everything, my lords, so that it will assist my learned friend also, and I'll make sure we give a copy to my learned friend in advance before we actually address your lordships.
My lord, just one request. The government order, my lord, constituting the secretariat, the same may please be taken on record, my lord,
Yes.
because that's a laudable step that the state government has taken
Will be on that day.
on that day. Please, my lord.
My lords, may not have it on any date other than the 22nd, my lords. 19th of July, my lords, if it's not inconvenient, my lords.
19th of June.
19th, also great.
Let them give us a comprehensive list of what they expect out of the state, my lord, and we shall work accordingly. Much.
Number 16. Sir Kushal Kumar Kaushik, party in person.
Respondent number 7, my lord.
Petitioners, madam. My lord, the essential issue that is being brought before this court is with regards to the practice of Asthi Visarjan, my lord. Now, the intention of this petition is not to seek a ban on the practice, considering the value that it has to the Hindu religion, my lord. The petition only seeks to regulate it. And my lord, since that is the core issue of this petition, my lord, I would like to draw this court's attention to the practice of Asthi Visarjani, what are its components, and what is the procedure, my lord.
We can hear this at 2:30. 2:30 we can hear. This will take time, go on. 2:30?
Yes, my lord.
Number 17. Dinesh, yes.
Appear for the petitioner, my lord, in the PIL and for the respondents, my lord, in the appeal.
17.
My lord, this is with respect to monthly pension, my lord, of industrial workers who retired or who had retired, my lord, on VRS basis. My lord, the pension that was being paid to them was very meager.
May I
My lord,
make one submission, sorry, my learned friend, commences on 22/4/2024. I had referred to a power of the central government to modify the scheme. This is relating to modify the pension scheme of 1995 and in the year 2007 and 8 minutes. This is the question which requires to be answered. And that day, this honorable court was pleased to pass an order, direction to place on record all the schemes which have been modified will be placed before both the houses. 22/4/2024 minutes.
So what does para 12 say? 12?
My lord, para 12, my lord, of the EPF pension scheme.
Where is it? Page? It is will found where?
Now, my lord, the initial scheme, my lord, is at page 25 of the PIL. My lord, your lordship is referring to the writ appeal, or your lordship is referring to the PIL, my lord?
Yes.
My lord, initially annexure A was in force. My lord, the pension fixed under para 12 of annexure A was challenged before this honorable court. My lord, the writ petition came to be allowed. My lord, the order of the learned single judge, my lord, has been produced at annexure B, page 52. My lord, may I just read, my lord, the order passed by this honorable court. My lord, this was challenged in writ appeal. Writ appeal came to be dismissed. My lord, the matter was taken before the Honorable Apex Court. SLP also came to be dismissed. My lord, interpretation was left open. When the matter was pending, my lord, before the Honorable Apex Court, my lord, they amended this para 12. And also they brought two more amendments, my lord, to the pension scheme of 1995. In the meantime, my lord, a series of writ petitions were filed before this Honorable Court. All the writ petitions were allowed. And my lord, some of the employees had approached the Consumer Redressal Forum. My lord, matter went up to the Apex Court from the orders of the Commission. Finally, my lord, the learned single judge's order, which has been produced at Annexure B, my lord, was ordered to be implemented. In Annexure B, my lord, at the end, my lord, at page 56, the learned single judge had made an observation, my lord. This judgment is applicable to various workmen covered by the EPF and the schemes framed therein. Therefore, I deem it proper to direct the Commissioner Respondent number 1 to circulate this judgment to other commissioners for proper implementation of the Act. The benefit, my lord, under this Annexure A was ordered to be extended to non-parties also. My lord, this order became final. My lord, to overcome this judgment, my lord, they amended the very scheme retrospectively. My lord, that has been challenged, my lord, in this PIL. My lord, the pension that a retired employee who had put in 20 years, 25 years, 30 years services, my lord, it was ranging from 400 rupees to 700 rupees, 900 rupees per month.
So ultimately, what is the prayer?
Prayer, my lord, to seeking vastment of, my lord, the amendments, my lord, which have been produced at Annexure D.
This is PIL.
Yes,
This is a PIL.
How can it?
He is not even a member of the fund. He is not a member of the fund.
Was our
My
first
lord, it is a society registered by the,
That was our
This
first
is
primary.
individual grievance.
pardon, my lord.
Individual. group.
Individual grievance.
Your
My
lordship
lord,
is right.
it may, my lord, pension may not be an individual grievance.
Wow. Natural end. Everybody is not getting pension. And must. Somebody has grievance, he may come, he will come by way of petition.
My
There are
lord,
other mechanism to resolve his.
I may be
individual
permitted
grievance.
to place my lord DS Nakara. That also, my lord, was pertaining to pension, and my lord, it was filed by a society. This issue, my lord, has been answered by the constitutional bench.
Different notifications are of different
parameters.
Year. Why so many challenge?
That's one is pertaining to the
All
modification.
pertaining to same subject,
Yes, same, sir.
but different dates.
Different dates. Whether pertaining to levy of damages also is there, what he has produced at page number 64.
So we interested in the pension.
Pension.
His claim is only with regard to the pension.
That's a statement. Objections have been filed to this union. Paragraph 19 and 20 specifically it is stated.
He is also not a member of the scheme. Every one of them is a member of employees pension scheme.
Yes, sir.
He is a member or not?
The society is not a member. Society is not a member.
Society.
Yes, sir. Page
My
number,
lord, writ
paragraph
appeal, my lord,
19.
they are members. Writ petitioners, they are members.
Now, presently, we are discussing about the writ petition PAL. Paragraph 19 of the statement of objections, manners, and 20, it has specifically made it clear that the notification which are clarificatory in nature are issued exercising the power conferred on the government under the Act. Needless to say that the government has got power to issue notification to effect such notification retrospectively. There is no violation of the rights guaranteed under the Constitution to the petitioner as alleged in the writ petition. It is submitted that the benefits extended to the pensioners is out of the corpus created by the second respondent, and the benefits are extended in proportion to the contributions made by the petitioners, so also the government and also the employer. Needless to say that the benefits are to be paid out of the returns received out of the investments made in accordance with the directions of the Government of India. That is to say that benefits need to be dispersed based on the returns of investments of the fund to all the pensioners, in the context of which the government is competent to make, issue rule, declare returns, and issue proper notification from time to time. It is submitted that the petitioner society is not the member of the second respondent, nor it contributes towards the corpus created by the second respondent. The entitlement of petitions depends upon each individual, depending upon the contribution and service rendered in terms of the scheme formulated by exercising power conferred under the Act. The petitioner society by itself, who is not being the member of the second respondent, cannot maintain the above writ petition on the guise of espousing public interest. There is no public interest in the above writ petition. The entitlement of the benefits under the scheme is to be enforced by each individual on the basis of his contribution and the number of years rendered individually. In the circumstances, the above writ petition is devoid of merit.
We'll leave open for our individual members.
Only members.
Pardon, my lord.
We'll leave open for all individual members to approach if they agree. Authorities.
My lord, the other writ appeal, my lord, is filed by the other side, challenging the order of the learned single judge, my lord, in favor of the members. Petitioners, my lord, in the writ petition were members.
Which is that other?
My lord, there is a writ appeal.
That was not a public interest litigation in the
That is,
litigation.
That in that I am the appellant and I have challenged it on the ground that the honorable single judge has directed us to calculate the pension as per the unamended para when the amendment has already taken place and it is to be with effect from 16th November 95. So on that ground, I have challenged that order.
And that was not a public interest.
That is
litigation.
not a public interest.
It was
litigation,
filed
it is
by an
an
individual.
Notifications under this
To the Act minutes.
no.
Amended notifications issued by the government.
My lord, notification was issued, my lord, in the year, my lord, maybe
2007.
2007, retrospectively, my lord, from 1995. Nullifying the effect of the judicial orders, my lord, passed by this honorable court, which have been affirmed by the honorable apex court.
But that section was never challenged.
Pardon, my lord. That amendment subsequently came. There was no occasion to challenge it. My lord, may I just read two paragraphs, my lord, of the 83 Supreme Court?
Nakara.
Nakara. My lord, the writ petition was filed by a society and this very contention was taken, and my lord, that has been answered. It was not by a trade union, it was by a registered society. My lord, your lordship may kindly recollect. After retirement, my lord, there cannot be a trade union because there are no more workmen, my lord, of any establishment. And my lord, according to me, my lord, the principle in this writ petition, my lord, is covered by a subsequent judgment, my lord, in the case of Chairman Railway Board versus Rangadhamaya.
So you want the benefit from 2001?
Yes, my lord, from the date of entitlement.
Date of?
My lord, from the date on which they were entitled to.
Retired.
Retirement. My lord, in the other two, my lord, individual cases, my lord, where the writ appeal has been filed, my lord, the pension that the petitioners were getting was 782 rupees per month in one case and 585 in the other case. Their claim was 1,435 in the first case and 1,200, my lord, in the other case. But that is per month, my lord. Your lordship may kindly see, my lord, the financial position at which these retired employees are placed, my lord, having put in more than 20, 25, 30 years of service.
In those cases, they have opted for a commutation of pension for reduced pension that is prior to attaining the age of 58 years. So there is a 3% deduction in that. After all that, they are getting this. In their calculation, they are not taking into consideration all those issues at all.
Come on Tuesday, next Thursday.
Next Thursday.
Where is the date of it? Next Thursday will be which date?
20, my lord.
4th.
20th, my lord.
No, not next. Then come on 24th. 24th. Monday. 24th, 6. It will be Saturday. This Nakara is watered down now.
Pardon, my lord?
Nakara is watered down.
No, Nakara is.
No,
on
my
the
lord, it is
question
not.
of,
On this point, it is not watered down, my lord.
That was on a different aspect because Article 14 was considered in that. And here it's entirely different.
So all individuals' service conditions, number of years of service, contribution and revenue, and there are so many other factors, economic factors, which will be a point for consideration for determining the pension amount.
My lord, may I place, my lord, the judgment relied by me on before your lordship, my lord.
Only one judgment. Nakara only, no?
Number 18. Non-filing in contempt matter.
I think for petitioners in this case, my lord.
There was direction issued by the Honorable Court, my lord, by the land single judge, my lord, to consider the representation of the petitioners as per, my lord, internal page.
Lord, in this matter, my lord, endorsement has been given. My lord, shall I pass on? My lord, it's been. Oh, I filed the. But there was a direction that it should be considered, and it has been considered, my lord, and awaiting the survey report, my lord, the authorities, my lord, the commissioner of BBMP and the under the Ashraya scheme, my lord, the sites would be allotted, my lord.
Yes, what did you do?
My lord,
Only one submission, my lord. The endorsement issued, it should be not supported by the compliance affidavit, my lord. They have filed a memo. Rest apart, my lord, there was a time frame fixed for the compliance, my lord. My humble submission, at the time of disposal, my lord, let their direction for the BBMP for constraint time frame for the consideration of the direction of the so.
Representation is decided or not? Submitted with petitioner number 96.
now, my lord, as soon as the survey report is
Go the
given, my lord, the title deeds would be issued, my lord.
They just issued an endorsement stating that, my lord, survey will be conducted and thereafter steps will be taken, my lord. There was no specific time limit, time frame outcoming from the endorsement issued by the BBMP, my lord.
What endorsement?
My lord, time frame, my lord, it has to, the report has to come, my lord, the land has to be demarcated. Once the land is demarcated, my lord, the sites would be allotted and the sale deeds would be issued.
My only submission, my lord, let their time frame for that work also, my lord, because from past.
It is about what, Mr. Council?
It is about the houses that were allotted to the homeless. Yes.
Ashraya scheme, free
Ashraya
sites.
scheme.
Free
Ashraya
sites to be
scheme.
issued.
Ashraya scheme is a scheme of the Ashraya scheme of the government,
Sites
where
to-
homeless people are allotted houses, EWS, economic weaker sections.
Land is to be allotted or plots?
Plots,
Or
plots,
house-
my
Plot,
houses?
plots, my lord.
So that is the direction.
That's
Yes,
the
ma'am.
direction.
That is the representation.
To consider the,
To consider.
to consider.
And now,
Considered.
That is, they have to answer, BBMP has to answer.
that is what, my lord, now the survey has been conducted. Once the land is demarcated, my lord, the free land, what is available, my lord, the land, it will go to the Ashraya scheme.
So we dispose of the content. Within what time will likely to complete?
There's no time
Within
granted.
what time will complete the exercise?
4 months.
Within, Lord,
4 months.
no, not 4 months. It has to be, land has to be demarcated, my lord. At least to 3 months' time may be granted.
We are saying 4 months.
Sorry.
We are saying 4 months, you are saying 3 months.
No, my lord, 4 months only.
My learned friend confused to 4 weeks.
I
Please, my lord,
got it.
if at all there are, I liberty reserved for me to revive this content, my lord. My only
No.
submission is that.
No purpose will be served in keeping in pending.
Please, my lord.
As per order dated 18th July 2022, from allowing a single judge allowed the writ petition in part to direct respondent 3 and 4 to consider the representation of the petitioner number 96 as Karnataka Dalit Hindu Li Avara Samagra Adi Abhivrudhi Sangha made to respondent 4 within 4 months, full stop. The grievance was about, the grievance voiced in the petition, writ petition was about allotment of sites and the issue of hakpatraks to the petitioners in the land bearing survey number 8 of Vadda, Rapalaya village, Uttarahalli, Hobli, Bengaluru, South Taluka. Learned, this is what
3 and 4, 2 and 3.
BBM.
BBMP.
when the petition, contempt petition came up for consideration today, learned advocate Mr. B.L. Sanjeev
BL Sanjeev.
submitted memo dated 13/6/24 to submit on that basis that the steps are already taken by the respondent number
2 and 3, man.
2 and 3 for complying with the directions of learned single judge. He submitted the process involves identifying of the land and undertaking the procedure before the actual allotment could take place. Full stop. In the memo aforementioned, comma, following is taken, following is stated, then vacated portion with regard to the representation. An Astra committee of the court, full stop. The aforesaid details, aforesaid statement and the amendments made in the memo go to show that the respondent authorities have started to act in compliance of the directions of the learned single judge. However, having regard to the process to be undertaken, it is to necessarily consume time. Full stop. Learned advocate for the respondents, number 2 and 3, paragraph. Therefore, submitted that time may be granted they submitted that within 4 months, the process will be completed. Full stop. The request is reasonable. Full stop. Since the request is reasonable, full stop, paragraph. Since the authorities have activated themselves in the compliance of direction and the progress is shown, it could not be said that they have been committing any contempt of the court, much less a willful contempt. Full stop. The present proceedings are therefore closed at this stage, allowing the respondent authorities the time of 4 months to complete the process.
My humble submission, am I at liberty to revive this?
Give 15 weeks, 15 weeks to complete the process.
I am at liberty to revive if at all they are not complied with my humble submission.
You have said at this stage.
Please, please.
The present contempt in the according
Obliged.
Number 19, Venkatachalapati.
This was serial number 18. Now 19.
But the accused has taken sufficient time madam. They have not complied the orders of this honorable court. Maladi has undertaken to file the report on 28/3/2024, madam. The advocate who is appearing on behalf of accused has undertaken on
The only direction in
28/3/2024.
in the contempt petition is to dispose of the representation of the petitioner if not disposed of. Who appears?
No one is appearing.
The direction.
See Ravindranath.
Page 11 is there. Page 11.
Please.
Page 11 is the direction.
Page 11.
Direction is at page 11.
Yes, ma'am.
Verify.
Time is not fixed. Time is not fixed.
Directions to be complied with are at which page?
Please, page number 11. ma'am.
11.
Please.
To Cali. Full stop. Then a single judge, while so providing, has not set down any time limit for deciding the representation. In the circumstances, it is not possible to conclude that by not deciding the representation, the respondents have committed any contempt, much less willful contempt. Paragraph. However, at the same time, it is right that the order of the court should not go uncomplied with. In that view, it is provided that the representation shall now be decided within a period of 8 weeks. Most of the contempt proceedings are disposed of accordingly.
Liberty may be granted. Liberty may be granted to. It's not
Any
compliant.
liberty. There is no decision on liberty. Liberty has to be after. Everywhere liberty.
Please.
Lawyers are most liberated persons.
Please.
And we are bound.
Acha bolo.
Issue number 20, to Virupaksha PH.
Yes.
Yesterday's matter now.
This is the matter which has been spilled over from yesterday, my lord. The matter which has been spilled over from yesterday.
Yesterday.
The writ appeal.
Writ appeal.
The writ petition. The writ petition arises out of a notification which is referred at ink page number 67. If your lordship is pleased to take page number 67, my lord.
You are saying that the circular is.
Yes, ma'am.
Yes, ma'am.
Yes,
Perfect
ma'am.
with the rules.
Contrary to law.
Where is
That's
it,
all.
sir? Where is the circular?
Kindly see, my lord, rule and circular, both.
Both letters.
Yes, ma'am. Kindly take page 67, my lord. 67 is the rule.
May
10th May
I appraise-
2020.
May I
Rule
appraise
is
your
framed.
lordship, my lord?
No, you will appraise, but let us see first.
It's a
circular.
very
Yes, ma'am.
narrow compass, my lord. If I have a case, he has a case, he has a case. Otherwise, we have no case, we have no case. Page 67, my lord.
Page.
Page 67,
Of the appeal paper book.
appeal paper book. 7th May 2020. Rule is prescribed 10% of post promotion filled up by a promotion among in-service meter readers, operators, overseers, assistant keepers on the seniority merit through selection after interview by a committee constituted by corporation. Not minimum qualification they say, not they must possess the diploma in the respective discipline subject. Not kindly see the note also that seniority and qualifying service shall be reckoned from the date of initial entry of service. Resolution says, not now, contrary to this, it clarifies if a person takes transfer from one unit to another unit, his seniority is not from the date of transfer. He has to go down. But
that may be also initial date of service.
Right?
Yes, ma'am.
Rule is otherwise.
No, the transferred place is which place? Department?
One unit to another unit.
Unit.
Circle wise.
Circle wise. One circle to another
wise,
circle.
not one
Question
unit
is
to
rule
another
says.
unit. It's a circle wise.
Circle wise.
Rule-
ma'am. Like
rules-
for
Circle
example,
wise is seniority.
similar.
for example,
Promotion
may I
only
clarify?
intercept between the circle.
It is only internal transfer.
Yes,
Similar.
internal.
But rule
Internal.
says.
May I
rule-
clarify that, my
No,
lord?
but
A
rule says-
person
one minute,
working
one
in
minute.
Bangalore, if he opts voluntarily to go to Kolar, Mysore, or Tumkur, he will be placed below the persons who are already working in that circle.
Yes, my lord. That is
That
agree.
is what, when an appointment is
But the
made,
rule says initial appointment, seniority must be from the initial appointment,
That is-
notwithstanding the transfer.
There are judgments of the Supreme Court on this line.
yes,
Yes,
ma'am.
my lord. Kindly see the latest judgment on hand. Between the resolution and the rule, which will prevail?
Not resolution in the rule.
Here,
When it can
resolution,
be
my
said to be a
That is a very broad principle.
My lord, broad principle is, my lord, one unit transfer another unit, my lord. It says, my lord, it is in public interest, his seniority will be counted. If it is on his request, he will take bottom seniority. That is the rule. That is the broad principle.
That is what the
Accept that,
undertaking I
Lord.
just.
I am not
produced.
saying that.
Transfer is internal transfer and it will retain the initial date of the original entry.
From he,
Or because of the voluntary
he was
Yes, Lord.
transfer.
on their request.
On their request.
But on
He was working in one circle. Thereafter, on his request, he was transferred to present circle.
correct, my lord.
If such a
We all
situation, how
agree.
his seniority
Yes, yes.
and
He will lose seniority.
Yes, my lord.
But
That is
the
our
rule
point.
is
has to
otherwise.
forgo his
No, no.
rules.
Where is that rule? Let us.
Condition,
That is
page 67.
154.
Page 67.
Page 154 is the rules.
Is not the.
Page
Condition.
154 may
Ala.
kindly be seen.
Page 67, condition, my lord. Page 67, rule. This entire rule I will read, my lord. What it says, Lord, method of recruitment, promotion.
Where are the rules about that?
My lord, 154
one
at
minute.
annexure
My
J.
lord, one narrow,
I have the original
One
book.
second, one back.
it is in a very narrow compass, my lord.
The Xerox is
Rule
placed in
says,
my
Lord,
paper book.
Seniority and qualifying service shall be
If
recorded.
all together are arguing, nobody will be
That
promoted.
Yes. I want to show, my lord,
Now,
May-
where are the rules indicating the
Yes, ma'am.
internal transfer?
Yes, ma'am.
That shows. Page 154.
Yes, my lord. Annexure J, page 154.
Annexure J1.
Yes. It's a rules regulating an area of seniority.
These are
Yes,
Kannada.
in which, my lord, your lordships may kindly go to page 158, my lord.
Yes. It is there in 160.
158.
Last paragraph.
Yes.
Then, my lord, may kindly go to para 6. May I read it, my lord?
Yes.
The transfer of a person in board interest from one group or grade of a service to another group or grade carrying the same pay scale or pay shall not be treated as first appointment to the latter for the purpose of seniority. Seniority of a person so transferred shall be determined with group grade, etc., provided that where the transfer is made on the request of the employee, he or she shall be placed in seniority list group or grade service, which she is transferred below all the employees born on that group or grade service before the date of the transfer. This is the regulation.
but
What the circular is issued is.
Now, what learned single is done?
let us interpreted the resolution and recruitment rules. Kindly
that
take note,
appears-
page 67. What recruitment rules says, my lord. There is a conflict between the resolution, recruitment rules,
We'll continue.
and
We'll continue after.
yes.
that.
May I make one? My mat is listed today at serial number 62. I am not being permitted to participate in the counseling. I am seeking for urgent interim orders, my lord.
So what Supreme Court has done?
It has said no stay of NEET counseling. It will go on. Now the counseling may start anytime. As of now, it has not been notified because some of the NEET aspirants went to the apex court, my lord, and they sought for stay. Supreme Court said counseling cannot be stayed. Serial number 62, today it is there in the list. Therefore, I am, that it can be taken up in the afternoon. My humble request, my lord.
Day is not over.
My lord, yes, please, please. Yes, I am aware. That's why in the afternoon.
We'll take up.
Court officer. Your Lordship's leave, my lord. The seal number 64 relating to that pollution control board chairman who was removed abruptly. Though there was a direction by this court that he must hold his tenure till November 24, my lord. That is the direction Supreme Court has also observed. It is listed at 64, my lord. Some urgency because the government will otherwise appoint somebody else. We had mentioned it on Monday, your Lordship said directed.
AG is appearing in this matter, Lord. He's seeking some time, Lord. Your Lordship may kindly fix a date.
Let it be called out, we see matter, we'll see the matter. After this matter, let those two matters. One, what is the urgency in your part? Anytime.
Refuse to stay. That is the urgency. We start tomorrow, we start after a week also.
Your Lordship may kindly.
So your matter will take up on Tuesday.
Please, my lord.
Tuesday, so that.
But-
My only request is, my lord.
You
Let's
definitely.
see to.
64, my lord, our matter. 64.
Lord, 64 may be called the next week, Lord.
But in the meantime, they are going to appoint somebody else into that
Are you
position.
going to?
No, I have no instruction.
Let there be a
It's
stay of,
already appointed, is my instruction.
Already appointed.
It's only an ad hoc, your lordship.
say, that is an ad hoc appointment, Lord. We're not talking about that.
No,
There should not be a
regular appointment,
permanent.
Are you going to make?
That I have to seek instruction.
That's okay. Wait.
Yes, please.
May I make one suggestion in this matter? Sit on an IA where I have brought for dispensation of translated. I'm not relying on those translated copies. It can come up for preliminary hearing or on IA.
Translated. No, both will take up together.
Please, please.
Both. Separate IA when the petition is pending cannot be taken up separately. Along with the petition will take up.
Please, my lord. But the extension is, my lord, again on Tuesday, if it does not be. Therefore, I am requesting that it be listed for hearing on IA or for preliminary. That is all. 17th is-
Both are listed together. Both will be heard together.
Please, I'll wait.
Now, page 153, we are on that. Page 154. What is this? In exercise of powers conferred section 79 of the Supply Act, Karnataka. They are the regulations, statutory regulations.
Yes,
So on page 158, read it again to recollect. The transfer of a person.
The transfer of a person in board's interest from one group to or grade of a service to another group or grade carrying the same pay or scale of pay shall not be treated as first appointment to the later for purpose seniority. And the seniority of a person so transferred shall be determined with reference to the station appointment to the group of grade from which E/C was transferred, provided that where a transfer is made at the request of the employee, E/C shall be placed in the seniority list of group or grade of service to which he/she is transferred below. All the employees own that group or grade of that service on or before the date of transfer. Here, my lord, person in the last date of hearing, that is on yesterday, I would just produce certain documents where they voluntarily, by an indemnity affidavit, they have stated that if they are transferred from one circle to another circle, their seniority may be pleased to. They are accept to that particular condition.
So they said that if it is transfer upon request.
Yes, ma'am.
Individually counted from the
Yes, ma'am.
new place.
Yes, ma'am.
Below those.
Below the persons who are already working in that particular circle. Here, the amendment as per 67, which was made, there was a note which says that from the initial date of appointment. Based on that, a few persons with an apprehension had approached this honorable court in a writ petition, which your lordship finds it at the order of that particular writ petition. Your lordship finds it at ink page number 132 of my paper book. The resolution which the single judge in the appeal before your lordship was also placed in this particular.
Now pursuant to this 158 rules, some resolution is passed.
Yes, ma'am.
Where is that?
Ink page number 67. An amendment was brought in.
67.
67.
That is the rules.
Yes, rules, ma'am. That note if your lordship, which the senior counsel representing the private respondents contended that was the question which there were misrepresentations, for which the same was placed before the.
Now
court.
this is the amendment to 158 page.
Yes, ma'am. No, not 158 amendment, to 12B1.
12B1.
12B1. May I have also placed what is 12B1 for your lordships up.
The 12B1 is what?
Your lordship is pleased to appreciate ink page number 229.
Yes.
229, chapter 6 of post of technical cadre filled by recruitment and promotions. In this, the relevant page, lordship finds 12B1 at ink page number 256. Now.
Yes.
256.
Yes. Ah, 256, yes.
On the bottom side, lordship finds 12. On the left hand bottom, 12. That is junior engineer, electrical storekeeper, circle wise. This is where is the point for consideration. Circle wise. And B1, the lordship finds it at 261. Well, B1, your lordship finds that.
10% of the.
Yes, ma'am. If this is read along with 67, my lord, amendment to this was placed, and to that there was a note which says that initial entry of service, which created some confusion during preparation of the list, for which some persons with that confusion approached this honorable court in the writ petition, which came to be disposed of. I will just place that at ink page number 132, my lord, before the single judge.
One.
132 of my paper.
Yeah.
Your lordship, the relevant starts at 145, my lord. May I read out, my lord? Paragraph number 2. So and so, learned counsel appearing for the respondent corporation has filed a memo dated so and so, enclosing the copy of the resolution dated 29/2022, and it is submitted that the resolution is in the nature of clarification to the earlier amendment dated so and so. Said submission is taken note of. Learned senior counsel appearing for the petitioners in WP number so and so, and other learned counsel appearing for the petitioner submitted the grievance of the petitioners has been addressed by the resolution dated so and so, and accordingly they submit that if the respondent corporation were to continue in terms of the resolution, they have no grievances in the matter. The said submission is taken note of. So by virtue of this taking note, and furthermore, my lord, paragraph number 6 of that particular judgment, the honorable court also gave the other parties room where it is made clear that the said respondents are at liberty to make a representation regarding the grievances of the applicability of the resolution to the current promotion being exercised, being conducted by the respondent corporation, and the corporation to look into the same and pass appropriate or expedient. When such a room was given to any persons, any employees who are having any grievances, they could make a representation, the respondent to consider. They do not make it. They approach the single judge by filing a fresh writ petition, wherein the honorable single judge, under an assumption that the clarification which is given by the board is of an amendment to an existing amendment, which is not permissible, he sets aside the resolution which is passed. Agreed by that, appear before your lordships in this particular writ appeal. Our contention is that it is a circle wise. Any person from one circle, if he opts to another circle, to the existing seniority, he will be placed below the existing persons already working in that particular circle here. That is what the amendment which the corporation intended to bring in.
Yeah.
So for a moment, for your lordship's appreciation, may I read out the resolution also, my lord, wherein no Your lordship finds it at page number 130, my lord, of my paper book.
14/10/22.
No, 20th September 2022, my lord. Page number 130 of the paper book, my lord.
20th September 20.
Yes, my lord.
Page number?
130, my lord.
Yeah, read, please.
May I be permitted to read it? Certified true copy of the resolution passed by the Board of Directors at its 132nd meeting held on 4th August 2022 at 2 p.m. in the conference hall of the first floor, Corporate Office, KPTCL, Kaveri Bhavan, Bangalore 09. Resolution. Subject 132/7. Issuance of a clarification regarding the promotion to the post of Junior Engineers Electrical under serial 12B1 of Chapter 6 of the KEB R&P regulations regarding. That was the subject matter before the board for consideration, Your Honor. Resolved that approval be and hereby accorded to the issue necessary clarification to continue to the following existing transfer policy and to issue clarification as below. It's only clarification which says nothing fresh has been incorporated to the notification which is at ink page number 67, my lord. I'll just read out what was the order, my lord. In order to protect the interest of the parent circle employees, specifically promotion avenue, in cases of employees who opt for intra-circle transfers on their own request, they have to forego their seniority for the purpose of promotion as per the transfer policy. This policy has not been challenged either by the employee union or the individual employees, as it is a generally accepted policy, and it has been followed by more than 30 years of all the circle cadres with assistant, junior, assistant operator, overseas meter readers, assistant storekeepers, assistant powerman, station attendant grade 2. The employees who are transferred from one circle to another circle shall be placed as a junior most in the respective cadre of the circle, and they are not permitted to be given preference and placed above the parent circle employees in the seniority list. Hence, the service rendered in the other circle by the employees transferred from one circle to another on their own request cannot be considered for promotion to the cadre of Junior Engineers Electrical under serial number 12B1 of Chapter 6 of KPTCL R&P regulations. Since the employees who take transfer should furnish an undertaking to the effect that they shall forego their seniority to the appointed circle before taking transfer to the other circle. Such employees cannot claim the service rendered in the previous circle, and they shall complete minimum 10 years of service in the transferred circle to get eligible for promotion. That was what the note. And yesterday I have also placed reliance, my lord, wherein the indemnity bond by the employees who are getting transferred are making an indemnity bond, which I have just placed the original as the copy of the Kannada vernacular language as well as the translated copy of the same before your lordship. Sir, nenne kottidnalla. Memo ಮಾಡ್ಕೊಡ್ತೀನಿ.
may I read out one of the undertakings which have been placed by one of the petitioners before the single judge, my lord, which is at ink page number 6 of my yesterday's document, my lord.
What is it?
That is the undertaking affidavits which they make, page number 6, if I draw my lordship's attention.
So, anything on your part?
I'm not disputing that. I'll say.
The only thing, Mr. The directions of learned single judge is only to consider the case.
Yes, my lord. Consider it as per 12B1, but the clarification what was.
All these submissions may be premature at this stage. Who is right, who is wrong?
If your lordship is pleased.
Read the page 38.
Yes,
In
ma'am.
light of the observation made above, respondent court was directed to consider the case of the.
If your lordship is pleased, paragraph number 15, under which we are agreed with, he squashes the resolution, my lord. Following the declaration law made by the apex court, I am of the view that if the respondent corporation finds any ambiguity in the rules, it is open for the respondent corporation to amend the rules. However, the existing rules cannot be clarified by way of a resolution. In view of the matter,
So, learned
WP
single
number.
judge is what is provided in rule to be correct.
Yes, my lord. That is the only stand what the respondent corporation. The resolution is only a clarificatory which has been given, which the learned single judge has set it put it to naught, your honor.
Paragraph 15 judgment, everything is.
Yes, my lord. Deeply obliged by that only we are.
Yes. We'll consider. We are not removing, sir. We are only thinking that if we remove, then things are not decided anything.
Yes. Lord.
And one more
Seniority
submission.
regulation is 261.
One more submission is before senior counsel continues. DPC is, as per my instructions from the department, DPC is completed. By virtue of this petition, we are not able to complete the promotional. Almost by virtue of this, around 2 lakh employees who are in the queue are getting affected, your honor.
Yes.
That's why this court is taking up the matter. I have no objection. Lord, page 261 is the regulation regulating the method of recruitment to the post of junior engineer 12(1)B. 12B1.
Page 158 are statutory regulations.
Right.
Page 158, paragraph 6.
Yes, ma'am.
That regulation only.
Statute.
This is a part of that regulation.
It is not just circular as you are trying to say.
No. This is part of that regulation. Kindly take page 261. Now I come to amendment. Page 261 says what? B1. Post of junior engineer B1, Roman 1, 261, which is seniority regulations. 10% of the post to be filled up by way of promotion in-service meter readers, operators, overseers, assistant storekeepers on the basis of seniority cum merit through selection after interview by committee constituted by the board. Promotion should possess acquire diploma qualification in electrical, mechanical, electronic, telecommunication, engineering of Polytechnic Karnataka. Should have put minimum service of 10 years as a meter reader, operator, overseer, assistant storekeeper. Should have passed executive lower examination, Kannada language, etc. This is the rule initially. There is no note added. It will be filled up based on seniority. This regulation is amended under Annexure C. Kindly take Annexure C now. C 38/2021, page 78. my lord. 30th August. But English translation is commencing from page 81. Page 81. And this is notification. Annexure C. Corporation, Karnataka Power Transmission Corporation Limited is willing to amend KPTCL employees recruitment and promotion regulation, employees provision rules, employees seniority regulation. Kindly note it. Seniority regulation. The title and commencement. These rules shall be called KPTCL Recruitment Promotion Amendment Regulation 21. Amendment shall be come into force as applicable from the date 24/6/21. Amendment to 12, serial number 12, B1. Kindly note it. Chapter 6, that is chapter 6, the old. KPTCL, employees recruitment and promotion regulation, employees provision rules and employees seniority regulations. Kindly now come to what is the amendment? Page 84. Note. Rest of them is no change. Page 84, kindly, my lord. Column 2. My lord, got it? 84, column 2. My lord, I will not read B1. Below that note, seniority and qualifying service shall be reckoned from the date of initial entry to service. So rules is amended to say that, my lord, whatever may be the transfer from one unit to another unit, qualifying service shall be from the date of initial appointment. That is the amendment in 38/21. That amendment is now clarified by resolution. Is it permissible under law is the question, my lord. That is annexure F, page 130. Page 130. Verification of that rule. But rule says, my lord, 38/21 rule says from the date of initial appointment, notwithstanding transfer. Resolution says, my lord, contrary to rule. Kindly subject resolution. Issue of clarification regarding promotion to the post of junior engineer electric under 12B1 of chapter 6 of KBRP regulations. Resolved that approval be and he is here accorded to issue necessary clarification to continue to follow the existing transfer policy and issue clarification as follows. In order to protect interest of parent circle employees, specifically promotion avenue, in case of employees who opt for inter-circle transfer on their own request, they have to forgo their seniority for the purpose of promotion as per transfer policy. This policy has not been challenged either by the employees, union, individual employees, as it is generally accepted policy, and it has been followed for more than 30 years for all circle cadres, assistant engineer, operator, oversee, meter readers, storekeeper, assistant powerman, station attendant, grade 2. The employees who are transferred from one circle to another shall be placed as junior most in the respective cadre of the circle, and they are not permitted to be given preference and placed above the parent circle employees in the seniority list. Hence, service rendered in the other circle by employees transferred from one circle to another their own request cannot be considered for promotion to the cadre of junior engineer under 12B1 of chapter 6 of KPTCL R&P regulation, since employees who take transfer should furnish undertaking to the effect that they should forgo the seniority in the appointed circle before taking transfer to the other circle. Such employees cannot claim service rendered in the previous circle. They shall complete minimum 10 years in the service of transfer circle, get eligible for promotion. This, my lord, runs contrary to the rules. Simple compose of, my lord, not only determination is whether this resolution can amend the 12(1)B note provided under the rules. That is 38/2021. That is, my lord, seniority and qualifying service shall be reckoned from the date of initial entry. What learned judge while examining this, learned judge held, my lord, resolution cannot amend the recruitment rules, regulations. And it is the reasoning of the learned single judge, relying upon not one or two judgments. But page 34, para 12, learned judge called out the seniority regulations and note both. Page 34, 10% of the post to be filled up by way of promotion from among in-service employees working in any lower cadre on the basis of seniority cum merit subject to evaluative vacancy. Note, seniority and qualifying service shall be reckoned from the date of initial entry into service. In the backdrop of these facts, impugned resolution dated 29/22 is passed by the respondent corporation, whereby verifying the things which are not incorporated in the said method of recruitment. On bare reading of the method of recruitment under promotion would indicate that seniority and qualifying service shall be reckoned on the date of initial entry into service, and that has to be considered in the light of seniority cum merit as stated in the proviso, namely regulation 12B1 of the said regulations. However, it is well settled principle in law, rule has to be made by way of delegated legislation, and same as tested only by way of rule, not by way of resolution, clarifying the respondent corporation. In this aspect of the matter, I'm 45 with the submission made by so and so senior counsel, relying upon judgment of the Honorable Supreme Court in case of so and so case, wherein it is stated, treated rules cannot be overridden by executive orders or executive practice. At para 3 of the said judgment is observed as thus. Then my lord, para 13. Then my lord, para the 13. Then other judgments. And then my lord, the learned judge only says, Lord, it is contrary to law. You are at liberty to amend the rules. I have no quarrel about it. The only latest decision on the hand is this. 23.
What you are giving?
Supreme Court.
Supreme.
I'll pass out.
Copy.
In the facts of the Ashok Ram Prasad case, my lord, in that case, my lord,
Referred by the
the
single
recruitment rule,
single judge refer ಈ judgment ಇವತ್ತು refer ಆಗಿದೆ.
Ashok Ram Prasad.
It's already been taken, considered by the single judge here.
ಇಲ್ಲ ಆಗಿದೆ. Ashok Ram. No. Yes, it is referred. It is referred. But question was, in that case, why I am empathizing, my lord? The recruitment rule says, my lord, Assistant Conservator of Forest in that, my lord, state of Maharashtra, they have to first go for training. Lord, on completion of training, they will be appointed. Seniority will be from the date of, Lord, appointment, not from the date of training. By resolution, my lord, they amended that their seniority shall be counted, right, from the date of the joint training. Examining that, my lord, Supreme Court says, my lord, that, my lord, the resolution cannot amend the recruitment rules. Therefore, it is liable to unconstitutional. Accordingly, my lord, court quashed it. But para 26 is the finding. 26. Finally, they read out the resolution. 26. I will read the 25. In service jurisprudence, service rules are liable to prevail. There can be government resolution being in consonance with or expounding the rules, but not in conflict with the same. On having set forth this proposition, we will now examine scenario of the rules prevalent. At we turn to the statutory rules framed. And the similar, there are 25.
25. Yes, yes, I am on 25 one.
Of judgment.
It starts like in service. to
Yes, Lord. Yes. On having set forth this general proposition, we now examine the scenario of the rules as prevalent. If we turn to the rules framed under 309 of the Constitution, 84 rules to refer to the appointment to the post of DFO, same is to be made by promotion from among officers of the Maharashtra Forest Service and also by appointment directly. Proviso to rule 84 rules is unambiguous, quite clear. The period spent on training at the government forest colleges and the period provision, including extending period provision, if any, shall not be counted towards the requisite period of service. Thus, what is envisaged is that appointment is different from recruitment process. What starts with the commencement of training, there can be possibilities of candidate not completing the training satisfactorily, thereby resulting in the candidate's removal on probation. Such probation can also be extended to see whether candidate improves performance. Government resolution at 25/90 upgraded the post ACF from class 2 to class 1. Proviso to rule 84 rules will continue to hold the valid determination of period service. Then, my lord, the resolution is passed. Para, my lord, 28. It appears that High Court's view is correct view. The resolution have been passed in the context that persons who have successfully completed the training effectively gets this monetary compensation for training period. He is not deprived of the same. This cannot amount to giving seniority from the date of initial recruitment process to determine interstate seniority. When the proviso to rule 284 rules make the date of appointment as direct recruitment clear, this is also in the background that while direct appointees have no experience in the field of having been freshly recruited, promotees have been doing tasks. But here is a recruitment rule says, seniority rule says, initial appointment. If they want to do it, they can do it manner known to law. Why, the object of that is, it is not one cadre. There are about 4 cadres: meter reader, lineman, mechanic grade 2, and several other cadres. The 10% is they must be qualified to hold the post, diploma they must pass, and 10 years service is the minimum basic. Therefore, object is that initial seniority shall be taken account, notwithstanding transfer of one unit to another in the lower cadre. It is to the post of junior engineer. Otherwise, my lord, rule will become redundant. Note of the rule will become redundant. If suppose, my lord, note is questioned, my lord may say that note cannot overrule the main part of the rule, but nothing is questioned. We have questioned only resolution. Therefore, my lord, note will prevail. That's all my submission.
Only one point may I submit, my lord. It is.
One clarification, I'm supporting the appellant. We are supporting the appellant. No new thing is introduced either under a notification circular, because your lordship may kindly go to page 154, Annexure J. It's a recruitment, just a seniority rules of the KPTCL. My lord, there are various provisions are there. Rule 2, my lord, how the seniority to be computed is provided. Then, my lord, if there are two groups, how the seniority be regulated provide subsequent rules. In addition to that, Rule 6, my lord, is an exception to the general rules. Under the Rule 6, it is made it very clear that if it is a voluntary transfer, it would not affect the seniority the transferee is concerned. If it is a transfer by request, it affects the seniority of the transferee. This kind of rules not only provided in this, in every service seniority rules, it is the rules. Now, either under the circular or under any other thing, no new thing is introduced. It is only a clarified because clarification is warranted because of circle-wise promotion is provided under the amendment. That confusion sought to be clarified by issuing a circular. Circular we are not employed for the purpose of amending the rules or other thing. It is only a clarificatory in nature. In all other aspects, my lord, we are sailing with the argument of my learned friend.
That is what the earlier writ petition of the single judge felt it. It is only clarificatory in nature, which I just produced at page number 132 of the earlier writ petition order here.
For learned advocate. Number 3. For learned advocate, so for the petitioner. You are senior counsel.
No, my lord. I'm H. Chandrachud.
Learned, senior advocate, Mr.
I'm senior counsel, M.R. Rajgopal.
Assisted by learned advocate, Mr.
Number 5 and 6.
Senior advocate, Mr. Assisted by phone number so and so. Headline. Learned advocates for the respective party stated that they argued the appeal finally. They further stated that the pleadings are complete and no further are required to be added or supplemented. Reserved for judgment. Reserved.
My lord, by virtue of this, there are other two contempt petition joint.
Contempt petition will go together on the day it will not.
If my lord, if
My
they
re-
succeed, my petition will go, otherwise no.
Contempt petitions are pending by whom?
Filed by
We
them.
find, my lord, we are,
Then contempt petition which arise out of the judgment and order,
it are clubbed
This-
together.
which the appeal was heard today and the judgment is resolved, will not survive, and that the parties shall be bound by the final outcome of this.
Deeply okay.
Disposed of a court.
There are two contempt petition arising out of
Both
this.
are-
Yes, my lord. In fact, I just secured the original
Now,
RNP
contempt may
regulation.
be taken up after disposal of appeal. If suppose my lord, pass order, I will say, my lord, no, contempt will not lie. If my
You
lord-
can file another.
For that was the reason I just even secured the original books wherein it could have been placed.
Wait.
Deeply obliged, my lord. If any assistance is there, the original RMP regulations also maybe place it on record, my lord.
Whatever you want to place on record, we are liberated ourselves from.
Yes, my lord.
Just now,
It is here.
who is he? There is some apprehension about some appointment.
Manoj, you won't make fresh appointments, Manoj, that we'll file our objections. Their in charge has been placed
Next week.
So when shall we take up this matter?
week after next, Manoj. We'll file our objections also in the
Then 2nd of July.
2nd of July.
But my tenure itself is till November. My tenure itself is till November.
Pardon?
My tenure, my lord.
I'll file my objection.
Period
And
as a chairman.
when?
It is till November. Very short period.
This is only July.
I'll file my objections, Manoj.
Nah, at least week after next, my lord. Any date, week after next.
It will not be possible next week. Let him file. Only 1 week is there. 2nd July is not far away.
Yes. All right.
Where should, please?
That undertaking may be noted.
No, man, your lordships
All right,
asked.
all right. All right. Once AG gives, fine.
When you make statement, we'll.
No, no,
rely
my lord. No, no. Once AG gives. we
Rely
are-
on this.
Once AG gives. Last week, is it possible? my lord?
I'm in some personal difficulty because it's the first week.
26.
26,
is fine.
26.
Yes, we have to file.
Third
Third would be better. Manoj.
Third would be difficult, your lordship.
You are
Supreme
coming
Court
from
will-
outside?
I'm
Is
basically from
from-
Karnataka, but now set 20 years in.
Supreme
Delhi.
Court opens on 8th, Manoj. Let it be on
I have some
2nd.
personal difficulty.
You are from- Whatever you choose.
2nd, Manoj.
26th.
26,
Manoj,
26.
26.
To file objections, Manoj, that's the only thing.
AG's team will be doing it, but AG will not do it.
That's the problem.
Request on the 26th, your lordship.
26th.
I'll let you know.
Well, please.
If not,
Translations have to be given.
We'll file it.
It's already been done.
Solid waste. We have complied. Please. In the preliminary hearing.
Office objection as regards, okay, the matter to be listed before this, let's say, before the division bench. In fact, initially we had filed a writ petition before, let's say, the single bench. He specific,
that has been overruled by the office itself.
no, because, okay, the office objection.
That has been overruled.
Please, Lord.
All office objections are overruled except translation.
Please, Lord. Under the category of preliminary hearing, Your Lordship.
Notice.
Till notice has not been.
Notice has not been issued.
Notice,
Not
the
yet issued.
formal
for-
notice.
First
notice.
time
Normal,
it's right.
first time it's coming.
Returnable on all learned senior education, so assisted by learned.
Vehemently argued.
To you give the kit.
Yes, respondent number
Whoever
five.
accepts.
Please.
26th of.
Fine, ನಾನು ಮಿಕ್ಕಿದದ sir.
Sixty-two, my lord.
What is it about? It is already adjourned, why?
No, that is 64. Mine is 62, which I had mentioned, saying that this morning the apex court, my lord, has declined to stay the counseling. And I am being prevented from
You're
participating.
threatening us with apex court.
My lords,
Apex court you are mentioning and threatening.
I want to participate in the counseling. I am saying counseling may start anytime.
We'll try to take up. We'll try to take up all matters subject to availability of time and capacity, yes.
Or may I just make one request? Ma'am? In serial number 62, the only office objection is regarding filing of translation.
Or dispense with.
Dispense with. That is all, my lord. And if it can be listed for preliminary hearing either on the 17th or on 18th.
Very good. 17th.
Therefore, otherwise it may not reach. That is the difficulty.
17th.
17th, oblige, highly oblige.
Shall start.
17th holiday ಇದೆ.
18th. I'm sorry. 18th. I'm sorry. Since my lord said 17th, my lord, I just.
Whatever you say, we accept.
18th.
Number 21. Remarks.
Yes, what is it? What is the content?
My lords, in serial number 21.1, my lords, 21.1, my lords, may I request for a 2 weeks accommodation. I'll comply with the office objections, my lords. And then they may be heard together, my lords.
Your Honor, this is the very same submissions made on the last two occasions, Your Honor. This is a very simple matter wherein BDA allotment had to be made in our
The last,
favor.
okay, yes, my lords, 2 weeks accommodation, my lords.
Yes, 22.
Still number 23. Joseph Anthony. Still number 22, sorry. Mr. Mohammed Zulfikar.
Your Lordship, you were supposed to file the reply. We have furnished a copy of the reply to the complainant. If your Lordship's permits, I'll file the reply before the court. If not, I'll file it in the registry, Your Lordship.
I'll 2nd July.
Number 23. Joseph Anthony.
The direction on.
Complainant, Your Lordship.
Lordships, learned single judge had directed us to consider the representation of the complainant. That representation has been considered, my lord, and an order has been passed. We are permitted to pass on the
Second July. So what is to be complied with?
Lord, the complainant had given a representation to the BDA saying that the area which has been relinquished in favor of the BDA, there is an encroachment in the said area and had requested us to take action.
Direction to be complied with. What is to be complied with?
Your Lordship, our representation had to be considered and documents if required had to be sought
Read
from us.
that direction.
Your Lordship, the writ petition order, I'll just.
Page number 15, my lords. Ink page 15, the last paragraph, my lords.
What you have done?
We have considered it, my lords. I may be permitted to pass on. The translated copy is at page 4, my lords. The complaint, my lords, so the complainant was that the relinquished area in favor of the BDA has been encroached upon by third parties. The BDA officials visited the property and, my lords, and noticed that the area which they claim to be relinquished is in possession of some third parties who claim title over the property.
So anything remains? Anything remains? You challenge this if you are agree.
Your Lordship, I will take suitable instructions. Kindly a date may be fixed, Your Lordship.
No,
I'll take instructions in this regard.
The representation was required to be decided by the competent authority as per the direction issued by a single judge in order dated 2/2/23. It is this direction which is brought under the contempt jurisdiction by filing this petition. Today when the proceedings came up for consideration, learned advocate so and so. B. Vachan.
Please, my lords.
Filed compliance affidavit.
I'm sorry, my lords, I filed a memo along with the.
Then a decision is taken upon the representation of the petitioner, full stop. This marks the compliance of the direction. Paragraph. It is observed that if the complainant is aggrieved by the decision, it is always open to the complainant to institute independent appropriate proceedings as may be available in law in accordance with law, for which, however, this court does not express any opinion. The contempt proceedings are disposed of.
24 to Parameshwarappa city.
Complaint. 20.
In this complaints of the a week's time may be granted, Your Lordship. Endorsement has been issued. We'll file an appropriate affidavit in this court. Week's time may be granted, Your Lordship.
What are the directions?
Within 6 months,
We conduct the Podi and Durust, Your Lordship. Endorsement has been issued.
Survey the
Survey of the land.
In such matters, you take instruction, make a statement and dispose. Unnecessary, this is.
No, it
getting
is not the
rotated.
Podi and Durust.
Yes, next 2 weeks.
Number 25, Mr. Pradeep HS.
I'm for complaining.
Yes.
We have complied the direction, Your Lordship. A week's time may be granted for submitting the reply. The direction is to form an association under 1972 Karnataka Apartment Ownership Act. We have formed the association.
What is the direction?
Direction is
Internal page number 20 only,
page number
20,
18 and 20, Your Lordship.
in last para.
Read it.
Therefore, the said clause shall be
You must
read.
know what you are going to comply with. You must know that what direction you are going to comply with.
Yes, Your Lordship.
What you are going to comply.
10 paragraph numbers, subclause 3. The third respondent is reserved liberty to get themselves registered under the Karnataka Apartment Ownership Act. We have formed an association under the Karnataka Apartment Ownership Act. And according to them, we have not complied it.
What about the second direction?
The respondent 1 and 2 are directed to cancel. The registration is already been cancelled.
So what remains now? in this
They,
contempt.
they had to register the apartment under the Act of 1972.
It was the following directions passed by learned single judge, which are brought under the contempt jurisdiction to be complied with. And fourth paragraph, 10 may I, 1, 2, 3, at page 18. Red flap, full stop. As far as the first, second direction regarding the cancellation of the registration of the society under the Karnataka Society Registration Act 1960, it was admittedly stated that it was undisputedly stated that the said direction is complied with. As regards paragraph, direction number 3, Roman small 3 of the Roman Stavo is concerned, learned counsel Miss, what is good name?
Beena.
Stated that the process is already undertaken and the association is formed. Association is
I'm
formed.
disputing that.
Association
They
is
are not-
formed, your lordship, as prescribed by the law. The law says that you have to execute
They have
a
not
deed of
registered.
declaration. We have executed the deed of declaration, but according to them, it is not done.
And necessary registration will be obtained.
Yes, your lordship.
Let him to furnish the document.
We have the deed of declaration copy. I can-
Within what time?
Tomorrow itself we can submit, your lordship.
Within 10 days.
Yes, your lordship.
Full stop. In view of the above statement, nothing survives in the contempt proceedings, they are disposed.
Liberty to approach if they have not complied. Liberty to.
Not complied with, then we'll see. Why you are apprehending non-compliance? You expect compliance?
Please.
Yes,
Number 26, Shravan Madhav.
Liberty may.
liberty is always there.
Lords, for the petitioners, the learned single judge order was to include the name of the
Accused
petitioners
number 2 in
within
this
3 months,
matter.
my lords, in the selection list.
My
There was a
lords.
time frame granted in the order, my lords. The order is at page 14.
My lords, the
So-
order of the division bench, we have challenged before the apex court, my lords, the diary number has been given, but there
My
is no
lords, the,
stay or,
This is division bench order.
please, my lords,
Please,
the
my lords.
division bench order, we have been challenged.
It was
Since it's a
stated by
big-
learned advocate Miss.
Sinchana,
my lords,
Francis Ford.
for accused number 2, my lord, for KPSC.
Good name.
Good, Sinchana,
my lords,
That the
one
order which
submission
is
is,
brought under the present contempt petition is challenged before the apex court. In that view. the
my lords, one
proceeding
submission, my lords.
can- As the Supreme Court is testing the,
My lords, my lords, there's a submission to be made, my lords. They have challenged it
Very
after the notice of contempt has been issued. The parent order has not been challenged yet, my lords. The order of single judge was covered by one judgment, my lords. That judgment they have not challenged.
order brought under the contempt is challenged or not? This very order is challenged.
My lords, this
because
order
there is
is
no
challenged.
stay, my lords, we have challenged it.
This very order.
Please, my lord.
This very order, my lords, but that very order was covered by the judgment of this
That you
honorable
tell-
court,
go to the
which was
Supreme
not challenged by them. my lords.
Immediately go to Delhi and tell the Supreme. Contempt will not proceed. After will proceed after Supreme Court decides.
My
Once it
lords,
is,
it may be kept.
this is all in the lighter way, but once the appeal is filed by a party, they should have right to take it to culminate, to take logical end. In the meantime, why contempt should be precipitated?
Even they are on the
Unnecessary.
caveat, my lords.
My lords, my submission is that they have,
Yeah.
They are,
they have approached after the notice of this contempt petition has been served on them, my lords. They'll have to challenge the parent writ petition if
Have
that is.
liberty for Supreme Court. argument. Here will, next.
Please.
27.
Number 27, Vinayak, please.
Yes, what is?
Here for the petitioner. Lord, the order of the learned
But,
single judge, my lord.
Only one submission. And against the order and I have filed a writ appeal number 731 of 24.
When it is coming up?
And all office objections are cured.
Then the contempt petition shall be listed along with writ appeal number 731 of 2024, in which the very order brought under the contempt jurisdiction is under challenge. Both the appeal and the contempt petition shall be listed on 4th July.
Please.
Before that date, if any objections are to be removed, shall be removed in the writ appeal.
Please.
Oblige.
Number 28,
Appear for the.
PS Nayak.
Accused respondent number 1 and for the appellant in appeal number 1601 of 2023, my lords.
Increment.
But I am for the respondent.
So increment is paid.
Yes, exactly.
So areas to be
They have
paid.
issued an endorsement,
Areas to be paid.
That's under challenge.
one additional increment for having passed the Kannada examination as per the government order. Since that was not given, my lord, I filed a writ petition. The department was asked to examine the case. Again, they, my lord, they did not consider. I filed one more writ petition. In there, my lord, there is a direction to give the benefit. The endorsement which they have issued annexure N, they say, my lord, that because of the financial problem, now they come out in the writ appeal with so many grounds. But what is their case before the, my lord, when the endorsement is issued declaring to grant the relief is, we don't have the finance. Once we receive the finance, we will give it. These are the only 5 employees left in the organization.
We do not know, you pay the areas of pursuant to increment. Nothing, we are knowing nothing. We are blind to everything except the direction in this contempt jurisdiction.
No, my lord, I'm for the respondent. I have
You shall
succeeded
compute-
before the landless single judge.
will compute and pay the amount. as
They have
approved.
to do it. Board.
You are going to comply with?
Well, I'm for the respondent employees.
That is what we are saying. Direction is against whom?
Against the board,
You are the
I-
company.
Yes,
I-
yes.
I'm the applicant.
Changing the side.
against the board.
Because,
I'm for the respondent. I'm sorry, my lord, some
But
confusion.
there is
because
an appeal,
I'm for the appellant in 160.
Comply with.
My lord,
my lord, there is an
The-
appeal
there is-
filed by them, my lord. 28.1.
there's an appeal, my
So
lord.
your appeal not given. Argue the appeal. Then now you are better, properly poised, yes. Yes,
My lord, in the year 1974,
yes.
the appellant
Where
company,
is the order, page 23?
Page 25.
25.
Right, same, page 3. So what was under challenge in the writ petition?
My lord, these employees are not government servants.
Huh?
These employees are not government servants. These are the corporation
That
servants.
is not the subject matter and ground. The ground is that you are pleading financial difficulty.
Just say, my
No,
lord, that,
Even the ground that was taken,
What you are arguing is not the ground of your order.
no, not in order, but
How can
these
you-
grounds were urged in the,
Because which order is under challenge in the writ petition?
in the objections, it was mentioned in the objections filed
Which
before the
order?
learned single judge, my lord.
Which order was under challenge in the writ petition? Or which circular was under challenge?
The
Page,
Page
endorsement issued was
endorsement
challenged.
page 101,
page,
101, translated copy,
10.
1. Endorsement issued to all these 5 employees. Worship gets it, page 101, my lord.
And the translation is at
The
101.
translation, yes, yes. Worship gets it.
Yes.
Presently, corporation has a net loss of 122 lakhs in the year 2019-20. The total loss rupees 183 lakhs. It is not possible for the corporation to pay the salary and other allowances to present staff and retirement benefits to retired staff. Apart from this, there are possibilities of loss during the time of auction of cashew due to COVID pandemic in the year 2020-21. The income of the cashew auction is the main source of income to corporation. In such a situation, it is not possible to corporation for bearing such additional administrative expenses. That's what they say, because of the financial problem.
Hello?
You take a decision to give.
Very
the
small
increment.
amount, my lord. What happened?
Then you say that no money is available. Why did you take the decision?
But this was,
Initially to take the decision to grant the increment on passing of some examination.
Yes.
my lord,
Can you say
this,
that?
my lord,
Yes.
this is applicable to the government servants.
That is not the, it never comes where what we are arguing. Now, you can't improve upon now. What you are arguing is not anywhere in the record or in the order.
And these are not the employees of government.
That is the novel thing you are arguing.
It is a position, man.
Position maybe, but novel.
We all
And
retired
we are-
long back.
We were on doubt whether on this ground we can even such an order. We don't have money, therefore we will not. You know, you don't pay is a different thing, and pass order in writing that we have no money, therefore we will not pay.
Kindly have this next week, my lord.
For what?
I would seek instructions and.
How
make
many
my-
employees are involved? How many?
Five
No, at
employees.
present, five
Around
employees.
5 employees, all of them retired.
Five
It's about
employees.
60 to 65,000 rupees per head.
Advocate. When do you want?
Next week.
1st of July.
No, 1st of July.
To be listed at 2:30.
Please, man.
Yes.
Kindly, serial number 35, if your lordship may kindly have it next week. A date may be given, short matter.
Here for the petitioner council.
What is it about?
Matter pertains to award of this coal mines.
Coal mine.
Coal. Next week, not any date which is convenient.
Whenever you choose.
Or
your
any
date.
date convenient to your lordships.
All dates are convenient. You choose your date. You are
Yes.
convenient.
Just inform me for the photo.
We'll inform the court officer.
Yes. So your original petition.
Indeed, minutes.
Yes.
Original petitioner and the appellant before your lordships. May it please, Millets. Millets, I may refresh your lordship's memory because last time I just began very briefly and I've given a short note of submissions, Millets, with a bit of a chronology just to put the issue in perspective. I will not be dilating on every aspect, Millets. Whatever the ground that weighed with the board.
Yes.
My lords could see, Millets, brief events I've just put under caption B, brief events.
You're referring to your note.
Millets, I've given, my lords have that one. Just below that, that could be seen, yes. The second page, my lords could see the brief events. Millets, it all began on 20th January 2017, Millets. Millets, the single window state level committee, SWSLC, they call it, Millets. It met and it decided in principle that it had to give the plots for industrial development, especially IT industry, etc. Millets. Then, Millets, when I applied, I was allotted on 20th Millets, February, rather April Millets, I paid 6.6 crore rupees. And later Millets, I paid some more amount. Finally, it came to 7.5 crore rupees Millets. What's material is that Millets, on 6/6/2017, my lords could see the date, the allotment letter was given. That my lords would find at page 86 of my writ appeal Millets. Page 86 is the allotment letter.
Shall we go to that?
Millets, I can take your lordships later if necessary, so that it may not be necessary right now. Millets, an allotment was made, and there, Millets, it contains certain conditions that I should pay the amount by so and so time, then how possession has to be delivered, how the agreement has to be entered into for a lease of 99 years, all these things, Millets, that have been spelled out in that one, Millets. Then, Millets, the correspondence began. My lords may kindly come to the next page. On 6/3/2018 Millets, I wrote to the board spelling out the difficulty I'd been facing. This may be necessary, Millets. For that matter, I put all the correspondence in a table, Millets. My lords could see, so that page numbers also I have mentioned. At the very beginning, Millets, and my lords could see the table. On the left side, I mentioned the communication from the board, Millets. The second respondent. May may kindly come to page 91 minutes. May I read this one minute? 6/3/2018 is the date minutes, because the rest of the communication also follows on the same lines. That's why minutes, if I could bring to your lordship's kind notice the tone and tenor of the first communication that may show the light which way it has traveled minutes. May I just read that one minutes. My lords could come to page 91. This is my communication that's dated 6/3/2018. So-and-so has proposed to establish software development center, so-and-so, with supporting infrastructure in 10 acres of land at plot number 18, so-and-so. However, we note that the said infrastructural works at the site have not yet been taken up, photos enclosed, and this would clearly, it would delay our implementation of the project too. You will also appreciate that the financial institutions who are backing our proposal for the total investment of 165 crores and more would like to ensure that the project is implemented without delay. Thereby, there are no cost escalation due to delays and resultant rise in interest costs. I'm sure you will concur with the above and take up the infrastructural work at the site at the earliest. Given the above, we would also request you time for remittance of the balance amount towards the registration of the lease cum sale agreement and also waiver of interest charges proposed so-and-so, so-and-so. This is what minutes, our communication. Then minutes, they've responded, they've extended the time. That's why minutes I've given the table when they have. I will take finally minutes to their communication as well, which is part of the counter they have filed minutes. Then minutes, my lords could see at page 92, another representation.
Page?
Minutes, page 92 minutes.
Yeah.
That's annexure F. We sought for the time on the sole premise that the infrastructure is not in place. It is your duty to take care of that aspect. Please extend the time, and in the meanwhile, comply with that one was our request. And Millard, that has been responded to, and they've extended. That's what they've filed in that minutes. I'll take your lordships later. My lords may kindly come to the next one. That's at page 95. Another communication on our part. My lords could see that one minutes at page 95. This also goes on the same lines.
Yes.
Then minutes, my lords may kindly come to page 120 before I could take to other aspects minutes. In the process, 120. In that process of our communication, since nothing has moved on their part except their granting extension after extension without complying with my request as to the infrastructure and reading the plot of litigation, etc. minutes, then minutes, I've just sent at page 120, my lords could see the demand drafts for the entire balance sale consideration or the consideration that's required to be paid on my part. My lords could see at page, that's annexure M1, 120. This is 5.2 crores. The next one, again, 5.2 crores. At page 121. The next page, 4.5 crores. The next page, 2.5 crores. I reckon, Miller, all that comes to 17.5. That was way back 23rd July 2021. My lords may kindly appreciate one fact, millets. I'm an NRI based in the USA, having my business arm here as well. The period, my lords could notice, it was the raging time of COVID 2019. Despite that, my lords, I continued to communicate with them. The office had been shut. And then, my lords, I made the payment in the sense deposited in their name. I have sent the photocopies saying that please, at least now, clear the litigation had been pending by then, and also requested that you should have minimum infrastructure put in place so that I could have my project taken off. This is how, Millets, I went on representing. Then, Millets, after sending this one, on 24/9/2021, this time I wrote to the Honorable Minister concerned, that's of large and medium scale industries. Look, I had even sent copies of my demand drafts, and I've requested these are the norms that had to be required to be fulfilled. Still nothing has moved. Please look into that. Then comes Millets, that's on 30th April 2022, a termination letter. My lords could see, Millet, that one at page 133. This is, Millets, in my humble submission without notice to me. They say that notice had been sent, it was returned with the endorsement insufficient address. Later, they say that they had sent it to my registered address in Hyderabad. They say that it had not seen the light of the day, though they have not produced any proof to that effect. My lords could see, this is the cancellation of allotment that was on 30th April 2022. This was a trigger point for me, Millets, to gather further information and file the writ petition. May I read, Millets? As you are aware, an extent of 10 acres of land in plot number so-and-so, Bangalore, has been allotted in your favor with a allotment letter 6/6/2017 cited under above for establishment of software development center, ITS, with supporting infrastructure at the tentative rate of 250 lakh rupees per acre. As per the time schedule prescribed in the said allotment letter, you are required to remit a sum of 17.5 crores towards balance tentative cost of land on or before 5/9/2017. And also in para 4 of the said allotment letter, it's indicated that the allotment stands automatically cancelled if you fail to pay the amount within the stipulated time. In consideration of your request, approval has been granted with this office letter so-and-so, cited under so-and-so above for change of the company's name. Then, Millets, further in continuation, in consideration of your request, you were given several opportunities to pay the balance tentative cost of land along with applicable interest with this office letters dated so-and-so, so-and-so. But you have paid only a sum of 50 lakh rupees with a receipt number so-and-so. then onwards up to 21st, page number. My lord, that statement of objections filed by the respondent number 2.
Yes.
My lords got it? Yes, my lords. This is 3rd January 2018 minutes. Their first communication to me. My address could be seen, minutes on the left. This is the curtain riser millets. They have said that you pay the amounts. Here onwards millets at page 15, my lords could see their reference to my communication. With reference to the above subject, you are requested to remit a sum of so-and-so towards balance tentative cost so-and-so, so-and-so. Your failure to remit the balance land cost will result in cancellation of allotment on receipt of the balance. Now, my lords may kindly come to the next page, 16. Again, they refer to my letter, but never to the contents or my request. With reference to the above, this is to inform you, you are hereby granted. My lords got it at page 16. This is dated 24/4/2018. In the face of my letter dated 6/3/2018, my lords could see reference number 2. My lords could see with reference to the above, this is to inform you that you are hereby granted 45 days extension of time up to 8/6/2018 to pay the balance land cost regarding allotment of land so-and-so. If you fail to pay balance so-and-so, so-and-so. My grievances not have been adverted to. Then goes millets. Next one.
On this date, what was the amount payable?
Beg your lordship's pardon.
On 24/4/18,
17.5 crore rupees.
18.14.
I reckon by then we have paid millets. 17.5 was the one that had to be paid. My lords could have seen the demand drafts where I have taken for that amount.
17.5 crores.
Yes,
was due.
Due.
For that 45 days were given.
Every time millets, they have given 45 days. Whenever I asked that, these are the problems I've been facing.
Did you not pay? Why? What
Millets?
prevented you to?
To prove my bona fides, I even remitted the amount in the bank. And I've sent them the demand drafts.
No, within time, why did you not?
Millets, within the time, I did not pay for 2 reasons, millets. The land had been embroiled in litigation. There was a civil suit pending by the landowners. There was a writ petition pending by the landowners. And prima facie, this honorable court observed that they still are in possession.
Landowner means?
The landowners from whom it's been acquired. Initially, the state acquired millets and it's been passed on to the board so that it could be given for industrial development. Millets, in that context, I have just brought to their notice, these are the problems we have been facing. We have also told them that we went over there to inspect and other things. There was resistance. Then millets, we requested that at least electricity should be provided so that I could have my project to begin with. Then they go, millets, the officials go and try to erect something to lay the lines, and they were chased away. They filed the police complaint. Under these circumstances, millets, I could not pay, though I was ready with the money. And to prove my bona fides, millets, apart from all this communication, I have deposited in the bank. I have sent them the proof that, look, I've already deposited. You please clear this one so that I could have that one. Otherwise, for years, I may have to struggle. And the project, time bound, could not fructify. Under these circumstances, millets, even they could not accuse me of saying that I've not been, rather I've been bereft of funds. I could not, that's why I've been dragging my feet on this one and I'm taking time. No, I have written to them. My lords may kindly see strangely, I have taken your lordships through a couple of correspondences on my part. I have raised a particular plea. Nowhere in their replies where they have extended the time have they referred to any of these aspects. They simply say in a routine manner, you pay by 45 days, we have extended. On what grounds have they extended, Millets? In my humble submission, having been impressed by my contention that I could not enter the plot, nor can you, because you have given a police complaint and litigation is pending. In all these circumstances, please clear those things, provide certain amenities, and then I can have it. This is how it has happened, Millets. Though they could be heard saying that 5 years and not. In fact, Millet, they've been extending. All of a sudden, Millets, on the last occasion when I sought further, because nothing remained, everything remained unchanged. In that context, Millets, all of a sudden, when I've written to the Honorable Minister, look, despite all these things, nothing has been moving from the board. Then, Millets, they cancel it, and without notice to me. The excuse they have offered is that, Millets, we have sent a notice, or earlier to the same address, I've had all the correspondence sent and received. And then, Millets, now they say that it was returned with an endorsement, insufficient address. They again say that then they have sent to my registered office address in Hyderabad. No proof with regard to that one. I'm afraid even with regard to the notice, which they say that had been sent back with insufficient address endorsement, even that has not seen the light of the day. May I continue? Millets, my lords, have seen at page 16, that's a letter dated 24/8/2018. Then come to page 17. This is 30th June 2018. Again, another extension at my request. At the bottom, my lords could see the reference to my letters.
Yes.
Then, Millets, it goes identically verbatim, saying that you pay without reference to what grievance I have raised. Then my lords could see at page 18. Here they mention 17 crores, Millets, that I had to pay. My lords could see this is dated 1/7/2019. Then my lords could come to page 19. Again, Millets, the same thing follows, 5/2/2020 at page 19, Millets. Then, Millets, at page 20, this is the change of nomenclature of the company. This has been there for the purpose of showing the address, my lords could see. Millets, then at page 21, this is what they've said that they've sent to my Hyderabad address. My lords, it makes an interesting reading, Millets, in my humble submission. My lords could see this is dated 26/7/2022. With reference to the above, a letter regarding cancellation of allotment of 10 acres of land in plot number 18 for non-payment of balance cost of land has been issued by the board on 30th April 2022 with a letter cited at reference above. The said letter was addressed to DIPL IT Hub Private Limited, Corporate Office number 120, so-and-so, Bangalore, but it's returned undelivered by the postal authorities stating that insufficient address. Hence, the said undelivered letter is enclosed herewith and sent to the alternative address as available in the file. Nor has it been received by me. Though they say that it's been with acknowledgement due and everything. The burden, Millets, in my humble submission lay very heavily on them. I'll come to that later, Millets.
Today, what is the position?
Millets, what they say is that, Millets, the next phase in this one is within no time, they receive another proposal from the third respondent, which had its partnership firm established 3 months earlier, and flat in 1 week, they conclude the whole thing. And they say that we have given it to that party. And Millets, they, to stymie the whole process, because I have filed a writ petition, then I have come before your lordships, and says that having paid around 30 crore rupees, they raise a loan of 25 lakh rupees on the property to indicate to your lordships that it's been mortgaged and third party interest has been created. Then, Millets, despite your lordship's directions in this writ appeal, that whatever the development should take place, they should be subject to the outcome. And they say, my lord, they have had a shell of a structure constructed.
The allotment to third party is also under challenge.
Indeed, my lords. Last time, my lords, I've taken your lordship to
But I
that
beg to
prayer
appear.
as well.
I appear, my lords. Construction has been put up, completion certificate has been given, everything has been done. My learned friend is now saying, my lords, it's. shell of a
Everything
company.
list pendants, my lords.
Sorry, it's not less pendants, my lords. The allotment was done subsequent to their cancellation. After allotment, my lords, the registered lease cum sale deed has been executed. After registration of that, we have applied for building permission. Building permission was granted. We have put up the entire structure. Completion certificate is also issued. All the photographs are before the court, my lords. So entire construction is put up, my lords. The allotment has ended up with the entire construction being put up and it's functional now.
At my cost, my lords may appoint a commissioner to see the level of construction, the level of operations, and the sort of employees they've employed, if at all.
A default, my lords, wants directions. Consistent, my lords, 30 days.
They
was the
say it's
time frame.
functional too.
30 days for the
They
time.
say it's functional too. At my cost, my lords may appoint a commissioner to see the shell and the bogey of it.
My lords, the learned single judge observes, first you cross your threshold as to why your cancellation was bad. Then you can come to the respondent, is what the learned single judge has observed. Here's a case, my lords, where for 5 years consistently he seeks for extension of time. He does not succeed. Then he goes to the minister. The minister also, my lords, does not come to the rescue. Finally, it's cancelled because, my lords, he is in default. That's what is noted by the learned single judge.
My allegation, my lords, the same third respondent was given 5 allotments up to now. 5 allotments. I've given a table. I've filed a rejoinder to that one. There's no answer. And to this day, not even a brick has been put on that one, on all 5 allotments. This is the 6th one. And the favored party for the board for whatever reason. I could understand, Millard, somebody who had been waiting, knocking at the doors for a decade could have been accommodated 3 months before that. They have it. And a partnership firm projecting that it's for infrastructure facility, not for industry. The very objective has been defeated. I'll take your lordships through that, Millards. The whole procedure, the proceedings where the committee, the land assessment committee has said, no, you don't fix into this scheme. That's why it cannot be granted. But the single window, suo moto changes the objective without referring to even the applicant, and they grant it. And my lords could see the timeline. I wish every department would work that fast. Within a week's time, everything completed. And my lords may could see whether it's been functional. What is the completion certificate? A few meters of the land, one corner, sort of an outhouse, just to show the bogey. I'll take everything through the record, my lords. We can't travel beyond the record. My lords could appreciate.
We'll continue Monday, Tuesday,
As my lords, please.
whenever you want.
Tuesday, my lords. I'm in your lordships.
My lords, I have some difficulty, my lords, if my lords may have it after the 28th, my lords.
We have no.
My lords, I have some difficulty, my lords, because the link is not available, my lords, from outside the country.
What is not available?
Link is not available, my lords, from outside the country.
Outside the country, not available.
They don't allow, my lords. I had some difficulty last time.
Whenever you want.
Can I request it after 28th, my lords?
Whichever date you choose, no difference.
On submission, my lords.
7, my lord.
But one,
3rd July, my lords?
3rd June. Grateful, my lords.
In the second set.
Serial number.
One submission.
Serial number 67. Time for
Millets,
respondent.
is it 2nd July, Millets? My lords.
Second.
2nd or 3rd, Millets? I just.
Can I request for 3rd, my lords?
So be it, Millets. 3rd July.
It could be at 2:30 minutes and 3rd.
Pardon?
It could be at 2:30 on 3rd, minutes. Grateful.
Grateful, Millets. Deeply obliged.
Serial number 67, my lord.
Serial number.
Serial number 71. 71, my lord. Not pressed.
Learned advocate for the
71, my lord.
contempt petition. The petition does not press the instructions on the petition, dismissed as not pressed.
67, my lords. I am for
Serial number
response.
68, my lord. There is a threat of disposition, short statement. Serial number 68.
67, I am for respondent. If the appellant obtained the interim order, my lord, they are not complied the office objections, my lord, till today, my lord. I am for, my application for vacating stay is pending. Monday or Tuesday it may be.
Monday.
Serial number
My
57,
lord,
my lord.
serial number 39, my lord.
Yes, yes.
Serial number 57, my lords. There's urgency because the employment status has been withheld because of this proceedings, my lords. So there was an understanding that we would go ahead with the matter today. On the last occasion when it
Who
came up,
appears?
I also appear in. my lord,
battery of other advocates, Mr. Palla sir is there, Naganan sir is there.
It can be in the week of 24th.
Week after this, please.
24th.
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 The matter pertains to appointment. of
19,
electrical
20,
engineer.
21 minutes. 24, yeah.
24th.
Could it be taken on 19, 20th or 21st minutes?
Difficult.
Then 27th. I believe. 27th, my lords. The other advocates are also
27.
grateful, my lords.
My lord.
My lord.
Serial number 61, I have a petition, it's election matter, my lord. Maybe take it over Tuesday, my lord. 61.
Which election? Which election?
My lord, it's society election, my lord. The appointment of administrator. Tuesday, my lord. Tuesday, my lord.
Why?
The election matter because the administrator was appointed on last November 2023.
Witness.
In fact, respondent number 2 has also been issued a notice from.
My lord, serial
So
number
serial number
63.
39, my lord, it's a PIL. And for the petitioner, I'm being informed that the nominations have been done. It can be brought on record. Tomorrow, if the matter is maybe posted, it will be concluded, my lord. Serial number 39.
My lord.
Serial number 33.
Not possible. Yes, ma'am.
My lord, it's for the election of the president and vice president of Karnataka Medical Council, my lord. Karnataka state has already nominated the members. It is for conclusion. If that can be concluded, the election will go further, my lord.
Tomorrow not possible.
Tuesday, my lord.
Next week,
Also next in a week thereafter. 10th of July, yes.
My lords, serial number 6, my lords. Kindly it may be taken up 19th, my lords.
19th, 19th July, yes.
My lord.
Yes, madam.
My lords, urgency is there. My lords, that is the serial number 6, hazardous material is there. That is a dangerous warning, the passed over matter, my lords. Due to urgency is there.
From next Monday, we are
Tuesday,
making week for a 10 days week.
Tuesday, my lords,
Every week we'll have 10 days now.
apprehension is that in the industry, there is a hazardous material that is dangerous. One day is important for.
Not possible, mister. We can take up at the earliest on
20th.
25th. Otherwise not possible. What is the matter?
My lords, the industry is stopped from processing there is a hazardous material. They have given permission to for a period of 7 days. That needs more than 1 month. More than 5,000 tons is there. They have stopped me, closed me, seized. That's a dangerous material is there. Pre-processing the hazardous material that is there in the premises.
Next Wednesday.
Wednesday, please.
That is already over, yes.
Lordship, item 51, Lordship, there was a PF which was to be by the child custody matter.
That's
And-
Supreme Court matter.
No. This is a child custody matter in which there was a requirement to serve the other side. We have served them through email. However, there's a PF requirement. We request a short date may be given in this matter, and additionally, we may be allowed to serve them on email again.
All matters cannot be kept. So
Lordship may have it end of this month at least, Lordship.
27th.
My
20
lord.
28th,
Serial
Lordship.
number
Can be on
63.
28th.
Your
Grateful.
lordship, My lord, serial number 63.
Your lordship, serial number 72. Your lordship had given me 24 hours to get back. And today it was not called out. So if you could kindly give me a short date.
Next Thursday.
Okay.
My lord, serial number 63, my lords.
33, if I may.
Okay, after.
Interpretation has been absolutely barred in this case, despite an order being passed on mutual consent. It's a joint memo on which an order was passed and still it's not being followed. It may be taken up next week. I'm having no access to my daughter.
Next Friday. Next Friday.
Your Lordship.
My lord, serial number 6.
Serial number 46. There is an order passed by the court directing the Labour Commissioner to do something that's outside the Industrial Disputes Act. Requesting for an admission, my lord. My appeal will become infructuous because I'm exposed to a lot of commercial.
What will become infructuous?
The writ appeal will become infructuous, my lord.
Next Friday.
My lord, serial number 63, my lords.
Your Lordship, serial number 31. There is an order passed in my favor directing KIDB to allot 300 acres of land and the demand note. The KIDB is creating third-party interest on the land despite of the direction, Your Lordship. Writ appeal and the SLP has been dismissed. The first round of contempt proceedings were disposed of with the direction to comply within 6 weeks. But no steps have been taken, Your Lordship.
What can be done?
May I request for a date, Your Lordship? Please
give as per court officers' discretion. Yes.
My lord, serial number 63, my name is reflected for respondent number 2, my lord, solely because I represented the respondent number 2 in the writ petition. I just have a memo to delete because I don't have instructions to appear, my lord.
Your Lordship, serial number. Your Lordship, serial number 45. Your Lordship, there is a transfer order which was quashed by the Lund single judge, Your Lordship. We have challenged the said order. And in the month of June, there will be a transfer, Your Lordship.
Month of June? What will be there in month of June?
Your Lordship, the transfer order was quashed by the Honorable Single Judge in the writ petition, Your Lordship. The said order has been challenged in the writ appeal, Your Lordship.
First July.
Much of 45.
Serial number 11, Your Lordship. Serial number 11 is a matter where 230 we had kept the appointment order. That is here, the contempt petition.
My lord,
Tuesday.
my lord, in serial number 13, nominations have been done. I'll bring it on record because for election of.
When it is posted.
Serial number 1, Aniruddhan. 1371 of 2022.
One 137 of 2022. Petition is dismissed.
Much.
Serial number 2, to B Ramesh, writ appeal 1508 of 2023.
State.
Here that provides second proviso to section 49. So we have held that 15 months time will start the first.
First meeting.
From the date when the new president comes.
Yes.
Not from the original.
Much of.
Otherwise, you have to defeat very provision.
Yes.
Because otherwise every time everybody will come and.
Grateful.
Much of it.
Observation.